Number one.
Yes, madam. My lord, may I plead?
Yes.
And this matter, my lord. My lord, IA is for my lord, we have filed for the determination of the age of the victims in this matter, my lord. What happened was that the series of application was filed before the concerned special court, and despite
No,
of
Mr. Mao, you tell me whether this appeal is ready for hearing. This appeal is ready for hearing or not?
appeal is ready for yes, paper book is ready, my lord.
Ready?
Yes, my lord.
And this IA is nothing but abuse of the process of the court. It has already been determined. Your revision petition dismissed by this court.
My lord, in the last
Where is the question of filing this IA?
in the last last paragraph, it is said that the fresh application can be filed before the concerned special court, and we have filed the
No,
application.
concerned special court, special judge has already delivered judgment.
Yes. Yeah, my lord. My lord,
Your revision petition was dismissed by this court. Then thereafter, by way of IA, you have again made the same prayer. Is it nothing? Is it not the misuse of the process of the court, abuse of the process of the court?
my lord, my issue was that
Your issue can be determined finally at the time of hearing the appeal.
that can be done.
If we find that there is no proper determination of case, we can set aside the judgment and remand the matter to the trial court to determine it again.
That can be done.
But at this instance, this IA is misuse, abuse of the process of the court.
Because IA, my lord, we wanted to place the record, my lord, because in the
What record?
especially a series of the documents which we tried to place before the special court, but the special court have not entertained our applications, especially the documents. When the trial was
Whether you have adduced defense evidence there?
my lord, some documents we have placed, but then we were insisting that there should be separate inquiry on that, my lord. That's how we filed the series of the criminal revision petition.
No, unless you adduce evidence, unless you examine the witnesses, how can you produce the documents before the trial court?
My lord, document was basically only they have placed only the part of the investigation. There was series of the documents which shows that the victim is a measure. So we wanted to file under the we wanted to use the JJ Act, my lord. So JJ Act, my lord, may we please to see JJ Act. There are two parameters, my lord. One is if it is filed before the JJ board. Second, if it is filed before the special court. So the special court has to do the inquiry under section 94 of JJ Act with 9 subclause 2 and subclause 3.
Now we will finally hear the matter. If you ready to argue the matter, you can argue.
Okay,
This we will dismiss this IA.
then my lord, can it be fixed tomorrow, my lord, for final hearing, my lord?
Tomorrow. Tomorrow.
Give some. Then I will not praise the IA, my lord.
Date of birth, date of registration of the license. Date of birth. If details are coming from the application, Judgment of it keeps it. I get it. Commission offense official. Then so higher process. Let's say.
Part Mr. Esmau, learned counsel for the applicant, and Mr. Ite, learned additional PP for the state respondent.
Victim is also appearing, the victim side is also.
Then Mr. Learned counsel for the respondent number 2. This interlocutory application is preferred by the applicant for determination of age of the respondent number 2 under section 94 and 9 within bracket 2 of the Juvenile Justice Care and Protection Act 2015, read section 54 within bracket 18, Roman 4 of the JJ Rule 2016 and 34 of POCSO Act 2012. Mr. Mao, learned counsel for the applicant, submits that the applicant is stood convicted by the learned special judge Bondila, special judge within the POCSO Bondila, by reviewing judgment and order dated 22/9/2022 and sentenced to suffer rigorous imprisonment for a period of
20 years.
20 years. 20 years. Mr. Mao further submits that the applicant at the stage of trial had filed series of petitions before the learned trial court for determination of the age of the victim. Respondent number struck, respondent number 2. Under section 94 and 9(2) of the Juvenile Justice Care and Protection Act 2015. Read with section 54, within bracket 18, within bracket Roman 4 of the Juvenile Justice Rule 2016 and 34 of the POCSO Act. But the same has not been properly determined by the learned trial court. And being aggrieved, the petitioner, the applicant has referred to a criminal revision petition before this court, being criminal revision petition 12 of 2023, wherein by order dated 16/6/2023, the learned, a coordinate bench of this court has directed the special judge Bomdila to determine the age of the victim by following due procedure and proceed with the matter as may be permissible under the law. Pursuant to the said order, the learned trial court has determined the age of the victim girl and thereafter
Your Lordship, on
finally heard the matter.
not basing on that order, Your Lordship, on basing on 17/7/2023, Your Lordship. Again, they have preferred revision. Page number 36.
So after this order, dated 16/6/2023.
Yes, your lordship.
15 by-
Thereafter, the trial court has determined the age of the victim.
No, your lordship.
not yet.
No, your lordship. The matter was fixed, and the matter on the merit trial, the final hearing, and the age will be determined together. That was the order by the special court. So again, they have challenged that order.
50.
So again, on 17/7/2023, by that revision petition, this honorable court was pleased to direct the POCSO court, special court, to comply with the order passed in 16/6/2023 and determine the age of the victim first, and then proceed with the final hearing of the matter, your lordship.
Malad, in three, Malad, dated 16/06 to 2023, that is first order. It was not complied. And then we again file another civil revision petition, that is
Okay.
to, as per the civil revision petition.
And thereafter, the learned trial court has passed an order that the age of the victim will be determined at the time of
Final
Final
hearing.
hearing.
Yes, your lordship.
and being aggrieved, the applicant again approached this court by filing criminal revision petition number 15 of 2023, and by order dated 17/7/2023, this court was placed to direct the trial court to dispose of the matter of age determination within a period of 1 month pursuant to order of this court dated 16/6/2023. And thereafter
Yes,
determined
age
the-
was determined.
and
Yes, your lordship.
thereafter the learned trial court has determined the age of the victim.
On
Correspondent
5/9/23.
Number 2. By order dated 5/9/2023. Thereafter, being aggrieved, the applicant again preferred on criminal revision petition being 24 of 2023. Challenging the order dated 5/9/2023. But by order dated 28/9/2023, this court was pleased to dismiss the said revision petition. Thereafter, the learned trial court finally heard the matter and convicted the applicant and sentenced him to suffer rigorous imprisonment for 20 years. Being aggrieved, the applicant had preferred an appeal, being criminal appeal number 34 written to get AP of 2023. And while the matter is pending before this court for hearing, this interlocutory application is preferred for issuing direction to the learned trial court for determination of the age of the victim. Respondent number 2 under section 94 and 9 written by 2 of the Juvenile Justice Care and Protection Act 2015. As the matter has already been decided by this court in the criminal revision petition number
24.
24.
24/23.
24 of 2023, this court is aware of the considered view that this interlocutory application is nothing but an abuse of the process of the court. And at this instance, Mr. Mao submits that he will not press this interlocutory application. You want to withdraw it,
Malad,
and he submits that he may be permitted to withdraw this interlocutory application. Where is accordingly allowed. This I instance disposal on withdrawal. So the appeal is not listed today.
No,
appeal is
It
not listed today.
listed only in connection with the.
yes, your lordship.
So appeal can be listed and for disposal.
When do you want?
This week, anytime, Malad. We can.
This week may not be possible, next week.
Next week, Malad, then. Malad, date may be fixed, Malad.
Mr. Mao submits that in the the original appeal may be listed for hearing, final hearing on 17. 17. Here is accordingly allowed.
Oblige.
Deeply obliged, Your Lordship.
Item number 3.
May I please, Your Lordship?
Yes,
My Lord, I am appearing for the appellant. It's an appeal against conviction under section 307 mainly, and also under the Arms Act. My Lord. 326 also, IPC. And he was sentenced to
Arms Act.
life imprisonment.
under which section of Arms Act?
Arms Act 27(1) and 25(1)(ba) of the Arms Act. My Lord, if we, Lordship may just turn to the FIR first, which is at page 1. It is filed by the brother of the victim. It says, may I just read? It is a FIR dated 28th of December 2020. It is to inform you that on 27/12/2020 at around 7 p.m. my elder brother Ravindra Chakma, 50 years of Nagavasti Yunchum village, Miao, informed that one Sri Bhakta Chakma of same village shot him with local made gun, Chakma gun, from the backside while my brother was returning home near agriculture field at around 6:30 p.m. As such, my elder brother sustained bullet injuries on his body and a serious condition. Immediately, he was taken to CHC Miao, from the where he was referred to Margareta Civil Hospital. From there, my brother was referred to Dibrugarh for further treatment. Therefore, kindly initiate necessary action against the culprit. My lord, the incident was occurred on 27th of December 2020 at around 6:30 as per the FIR. Now, if your lordship takes up the recovery memo first, I'm going one by one. Page 19. At beginning, page 18, it is a disclosure statement by the victim, that's by the accused.
Yes.
He says that he has concealed the weapon of offense, that is the Khaja Banduk, lock and made gun, at Newton village in Bamboo Grove near the house of Anil Chakma. Now, this is the next page, 19, is the recovery memo. May I read from the second paragraph? In presence of the undermentioned witness, accused Bhakta Chakma in custody, as per his disclosure statement, has led the police voluntarily and pointed out the place at Newton village, Miao, to be mentioned from where the articles where he concealed the weapon of offense, that is Khaja Banduk, local made gun, at Bamboo Grove near Anil Chakma's home at Newton village on 26/12/2020. Kindly note the date, Mana. 26/12/2020. The date of occurrence was 27/12/2020 at around 6:30 p.m. And the police has recovered by this recovery memo on 26/12 prior to incident, after his arrest. Now, in this matter, what happened during after committal, it was referred to District and Session Judge, Khonsa District at Arunachal Pradesh. The accused was provided with a legal aid counsel. These witnesses in the recovery memo are PW8 and PW6. Niti Mukhi Chakma is PW8. Now, your lordship will kindly take PW8, page 48. The Caesar witnesses. May I just
Yes.
read the may I just read the own oath? I know the accused person standing on the dock is Bhakta. I do not know about the case. One SBML and belongs to Bhakta was recovered by police from Bamboo Grove. Exhibit number 3 is Caesar memo containing my thumb impression. Exhibit 4 is the recovery memo containing my thumb impression. Material exhibit number 1 is the seized gun. Now the cross-examination was done by the legal aid counsel that seized gun was recovered from bamboo groves in the jungle. There is no mention of the place and time of recovery by the seizure witness. Even if your lordship goes to the recovery memo also, there is no mention of time of recovery. In fact, the date of recovery was also made wrongly, 26/12/2020. Now the other seizure witness, that is PW6. If your lordship again goes to PW6 at page 46. Bichwinga Chakma, he says police has seized, has your lordship got page 46?
Yes, yes.
Police has seized one SBML gun in my presence. As per instruction of the police officer, I put my signature as witness in the seizure. I have also put my signature on police station on another memo. Exhibit 3 is the seizure memo and 3 is my signature. Exhibit 4 is the recovery memo and 4 is my signature. Exhibit 2 is the material exhibit 2 is SBML gun, which was seized by police in my presence. The cross-examination done by the learned legal aid counsel, the gun was recovered from the bamboo groves. So there were two material exhibits, one material exhibit exhibited by PW8 and another material exhibit 2 that is also seized by from the bamboo grove. Here also the prosecution witness has not said where from the gun was taken by them. Now I am leaving aside all these things. If your lordship comes to page 36 first, that is the order of committal. The learned Chief Judicial Magistrate Changlang District has passed the order on 25th of August 2021. Now on page 38, this is the chart, framing of charge by the learned district and session judge Khonsa. 38, he was framed under section 326 of the IPC. And the next page, 27(1) of the Arms Act and 25(1)(ba) of the Arms Act. These charges were framed when there was no opportunity was given to the accused by way of legal aid service. Now, if your honor, the lordship finds that there were 16 witnesses, and out of them, all 9 were.
Mr. Dhor, on what basis you are submitting that without hearing the legal aid counsel, the learned trial court has framed charge?
There is no that is not mentioned in the judgment even.
It may not be, but definitely one order has been passed.
Maybe, my lord, I'm keeping it aside for the time being. But the thing is that out of 16 prosecution witnesses, on 9 were not examined. Only 6 were examined, and that too, I will read only one single line, 2-line examination was done by the learned legal aid counsel. If I take your lordship, every witnesses, page 40 is the PW1.
Yes.
He was cross-examined, page 41. When my elder brother Rabindra Chakma was shot, I was present at my residence, which is situated at about 6 km distance. I have not seen who has fired upon Ravindra Chakma. I am told by Ravindra Chakma that during the time of firing, no one has seen, but everyone has heard of firing sound. I do not know if there was any enmity between Ravindra Chakma and the accused. Before Bhakta Chakma confessed before the police that Ravindra Chakma was fired, I did not know about the same. Lordship will kindly note on another aspect of the matter. This incident occurred at around 6:30 as per the FIR of 27th of December. And your lordships are aware, and in the state of Arunachal Pradesh, the on sun during the winter, the sun sets around 4:30 p.m. and the incident was occurred at around
But
6.
Mr. Dhor, they are belonging to the same locality. They are familiar with each other.
Yes, my lord. Yes, my lord. That is true. But nobody has, there is no eyewitness except the victim
Maybe
saying,
why should we disbelieve the version of the victim?
my lord, disbelieved him because it was the incident was occurred at 6:30 p.m. in the December night when I have collected the time when the sun set on 27th of December 2020. It was 4:18 p.m. The sun was set and he was in agriculture land as per the FIR.
Hmm.
And there is no question put to the prosecution witness by the learned legal aid counsel regarding the whether there was any sufficient light, there was street electricity, so as to identify that accused person after firing the victim on the backside, not from the front side. The firing was made from the backside.
Hmm.
Now, informant, page 42. Lordship will see that why I am submitting, because before Lordship, the cross-examination part, I will come to that.
Hmm.
42, is the informant. I have not seen who have fired on Ravindra Chakma, but Ravindra Chakma has seen the accused has fired on me. Ravindra Chakma called me to come and told that he is fired by a gun. Now, page 43 is the victim.
Yes.
Kindly see the cross-examination of the victim. I have seen Bhakta on the place of occurrence with the gun on his hand. I was fired from the back. After I was fired, I have seen Bhakta. So no question was were put regarding the other circumstances under which he has seen, because he was shoot on the backside, whether there was sufficient light, whether there was any electricity by which the victim has seen only. Nobody, there was no other eyewitnesses. Now,
That's
at
all
the
right.
same
But
time,
Mr. Dhor, you see, whatever the victim has stated in his examination in chief, the
my lord,
same remained unrebutted in his cross-examination.
my lord, there,
You could not be able to elicit anything from his cross-examination.
that's what,
Rather, whatever you have elicited in cross-examination, it fortified the stand taken by the victim in his examination in chief.
very true, my lord. That is why I am aggrieved, because, my lord, your lordship, if your lordship kindly see the judgment also, in the judgment also, the page 79 at paragraph 27. Learned session judge has also observed that
Yes.
it is observed from the record that during cross-examination of witnesses, that is PW 1, 2, 3, 12, defense could not prove any contradiction in their statement. On the other hand, rest of the prosecution witnesses are not cross-examined by the defense. In view of the above, I am of the considered opinion that the deposition of the witnesses are trustworthy and reliable. Now, my lord, I am taking your lordship to the first initial pages of page 70 of the judgment.
Yes.
Paragraph 4. On being committed, present case is received by this court and the accused was produced from judicial custody. Accused has disclosed that he has not in a position to engage counsel for defense of the case. Accordingly, legal aid counsel Ms. S. Lawang is engaged to represent accused person as state defense counsel during the trial. Now, my lord, why I am submitting all this? Because your lordship is aware, in the case of Anokhi Lal, the Supreme Court has already held where in a case criminal proceeding, the conviction is likely to be of life imprisonment or death sentence, and legal aid counsel or amicus curiae be appointed who has a minimum practice of 10 years. In case of death sentences, a senior counsel has to be engaged. Now, this legal aid counsel who has been engaged for defending the accused herein had 5 years of experience at that moment of time.
No, it has also to be seen that whether 10 years experience lawyer is there in Sanglang, Sanglang or not, in Phunsa or not.
My lord,
That has also to be seen.
But the Supreme Court very recently on 2nd of December in the case of Ashok versus State of Uttar Pradesh, I have given a copy to the bench assistant. It was decided on 2nd of December 2024. The 3 judges bench has affirmed the Anokhi Lal case and also made some guidelines for providing these legal aid services. Lordship, I have sent through email the judgment. The Ashok versus State of Uttar Pradesh. First, I will like to take your lordship to the paragraph 7. Herein, a senior advocate was engaged as to assist as an amicus curiae. My lord, in our case, similar situation held in this matter. The learned senior counsel appearing for the appellant, paragraph 7 I am reading. The learned senior counsel appearing for the appellant as an amicus curiae pointed out that alleged recovery of the victim's slippers and underwear at the instant of the appellant is highly doubtful, as the place and time of recovery have not mentioned in the recovery memo. The prosecution did not examine the two witnesses to recovery memo. He pointed out that the prosecution made no attempt to prove the blood stains on the undergarments of the appellant were that the blood of the victim, no analysis was made. I'm skipping the rest paragraph, my lord. I'm taking to the relevant paragraphs. And at page 6, last paragraph, paragraph 19, failure to provide legal aid to the accused. After discussing all this, Anokhi Lal and other cases, the Honorable Supreme Court has framed some guidelines. Well, may I just read from paragraph 19?
Yes.
After having perused the case record of the case, we found a very disturbing feature. It is about the failure of the state to provide timely legal aid to the appellant. The other issue is about the quality of the legal aid. Apart from the provisions of Article 21 and 39A of the Constitution of India, a law on the issue of right to legal aid has been evolved by this court through the landmark decisions. This court's first well-known decision in the case of Husainara Khatun 4 versus Home Secretary of State of Bihar, 1981, SCC 98. In paragraph 7, the court held thus. We may also refer to Article 39A, the fundamental constitutional directive, which reads as follows. 39A, equal justice and free legal aid. The state shall secure the operation of the legal system, promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure the opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The article also emphasizes that free legal aid service is an unalienable element of reasonable, fair, and just procedure for without a person suffering from economic or other disabilities would be deprived of the opportunity for securing justice. The right to free legal aid services is, therefore, clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons of such poverty, indigence, or an incommunicado situation, and the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of the justice so require, provided, of course, the accused person does not object to the provision of such lawyer. We would therefore direct on the next remand dates when the under trial prisoners charged with bailable offences are produced before the magistrate, the state government should provide them a lawyer at its own cost for the purpose of making an application for bail, provided that no objection is raised to such. I am skipping all this. Then, Your Lordship, page 8, the Anukilal versus State of MP's case has been referred. And the conclusion.
No, Mr. Dhar, there is no quarrel about the proposition of law laid down in this case.
But the concluding part, my lord.
In the instant case also, the court had appointed a legal aid counsel. But according to you, he is only 5 years experience. But is it your case that
Yes,
there
and
was
the
10 years
lord,
experienced lawyer at Khunsa and the trial court has not appointed 10 years experienced lawyer? Is it your case?
Yes, my lord. Now, if your lordship kindly see the concluding part, let me just finish.
And you also tell me, is there any guideline is laid down by Supreme Court?
Yes, my lord. In this matter only.
No, first listen to me. That in the event of absence of experienced lawyer, what option is available for the court to be exercised?
My lord, because of in the villages like this Arunachal Pradesh's lawyers with having much experience is not expected. But although the state legal services authority has a role to play, and that is why the concluding part of this judgment, which is delivered on 2nd of December 2024, it's page 9. The conclusion and directions was given to role of the prosecutor and appointment of legal aid lawyers are given by the 3 judges bench of the Supreme Court. I skip all this. Last page, paragraph 10, page 10. Just G. As held in the case of Anokhi Lal 5, in all the cases where the possibility of a life sentence or death sentence on only those learned advocates who have put in minimum of 10 years of practice on the criminal side should be considered to be appointed as amicus curiae or as a legal aid advocate. Even in the cases not covered by the categories mentioned above, the accused is entitled to a legal aid advocate who has a good knowledge of law and has an experience of conducting trials on criminal side. It would be ideal if the legal aid services authorities at all levels give proper training to the newly appointed legal aid advocates, not only by conducting lectures, but also allowing the newly appointed legal aid advocates to work with the senior members of the bar for a requisite number of trials. Now I'm coming to J, paragraph J. In the cases where the offenses are of a very serious nature and complicated legal and factual issues are involved, the court, instead of appointing an empaneled legal advocate, may appoint a senior member of the bar who has a vast experience of conducting trial to espouse the cause of the accused, so the accused gets best possible legal assistance. Now, the L is very important. If legal aid is provided only for the sake of providing it, it will serve no purposes. Legal aid must be effective. Advocates appointed to espouse the cause of the accused must have good knowledge of criminal laws, law of evidence, and procedural laws apart from the important statutes. As there is constitutional right to legal aid, that right will be effected only if the legal aid provided is of a good quality. If the legal aid advocate provided to an accused is not competent enough to conduct the trial efficiently, the rights of the accused will be violated. Now, for these reasons, the appeal was allowed by the Honorable Supreme Court, and it was directed, paragraph 25, to all, it is forwarded to all state legal services authority to enable the authority to take necessary measures. And the learned Supreme Court has interfered with the impugned judgment of conviction, because in that case also the trial was not conducted really by the legal aid counsel. My lord, I have not taken your lordship to the entire evidences on record, but from the evidences available, whatever material available with us, it is seen that out of 16 witnesses, only only 7 witnesses were examined, and 9 were not examined. And even if we see the cross-examination, only single line was done, and there is
Mr. Dhar,
my lord,
there may be multiple numbers of witnesses, but you
Madam.
see from the evidence of the victim that except him, there was none at the place of
none
occurrence.
at the time. Yes,
Then what purpose will be served by examining the remaining witnesses?
my lord, the victim was not cross-examined. The victim was also not examined properly, because as from his own version, the incident occurred at around 6:30 p.m. on the December night, 27th of December, when the sun sets around 4:15 or 18 p.m. It was completely dark, and he was shot from the back, and after shot, he has seen that this accused person has shot him. These elements should have been brought by way of cross-examination by the learned legal aid counsel, madam, because only he has seen, my lord.
Yes. Any other point?
My lord, as I've stated, the recovery memo also says that there is some lacuna on the part of the police investigating agency, because they have not mentioned the time and the place where from it was recovered. And there are evidently two recovery witnesses who were present on 3rd of January 21. They exhibited 2 material exhibits. That is not possible, my lord.
Yes.
So, in view of my submission, this my lords may interfere with the judgment passed by and given the opportunity to the accused for a fresh trial by engaging an efficient legal aid counsel, my lord. That is my humble submission.
Okay. Okay. Yes, madam.
Yes, Your Lordship has rightly pointed out that with regard to the legal aid counsel, Your Lordship, they were very much represented at page number 36 even when the matter was committed to the Sessions Court, Your Lordship. They had come with a bail application, Your Lordship.
Have you gone to the record?
Yes, Your Lordship.
Whether at the time of framing of charge,
Yes,
the legal aid counsel was appointed?
that I'll just look into the record, Your Lordship. That part
Acha.
on the charge was on 22/11/22. I'll have a look there for you.
You
Yes. Yes, Your Lordship, during framing of the charges, he was represented by the same counsel who has represented him in the
Correct.
trial.
Correct.
Yes.
Okay. Okay.
So, Your Lordship, if I may take Your Lordship to the other point that was pointed out, Your Lordship, at page this disclosure, Your Lordship, recovery memo at page number 19, Your Lordship.
19 of the paper book?
Paper book, Your Lordship.
Yes.
Your Lordship will, there was a submission that the date of the recovery is shown in the recovery memo is of 26/12/2022, Your Lordship. However, thereafter, Your Lordship will see that it also reflects after committing of the crime, Your Lordship, where he concealed the weapon of offense Kaja Bonduk at Bamboo Group near Anil Chakma's home at Neoton Village on 26/12/2020 after committing the crime. So there might be wrong in recording the date, Your Lordship.
But whether you have clarified it from the IO investigating officer?
Yes, because this, as soon as after this date is mentioned, Your Lordship will also read after committing the crime. As per the FIR, Your Lordship, the crime was committed on 27/12/2020, Your Lordship. This is the recovery memo, Your Lordship. At page number 18 is the disclosure statement, Your Lordship. It was only on the disclosure of the accused that the recovery was made, Your Lordship.
Whether any statement under section 27 of the Evidence Act was recorded?
Yes.
Page number?
Disclosure statement. नहीं वो तो वो है recovery है. Disclosure statement is at page number 18, Your Lordship.
So can it be, after going through this statement, can it be said that the provision of section 27 is complied with in the letter and spirit?
I believe so, Your Lordship, because as per 27 statement, Your Lordship, only on the disclosure of if the weapon is found on the disclosure of the accused, Your Lordship.
Where is the disclosure statement?
Page number
By
18.
going through this page number 18, can it be said that it is a disclosure statement?
Your Lordship will see it, second paragraph, Your Lordship, in presence of the under so and so in police custody on integration has stated voluntarily that I so and so, son of so and so, village so and so, POPS district state had concealed the weapon of offense, that is Kaja Bonduk, at Newton village in Bamboo Group near the house of Anil Chakma.
And when this statement was recorded, prior to recovery of the weapon or after recovery of the weapon?
On the same date when the recovery was made, Your Lordship. As
That's all right.
because Lordship will the disclosure statement as well as the evidence recovery memo is of dated 3/1/2021, Your Lordship. And thereafter the seizure, Your Lordship will see. At page number 11, Your Lordship.
Yes.
Page number 11, serial number 2, Your Lordship, date and time of the seizure.
Yes.
Yes, Your Lordship. Now,
Whether the gun was sent for FSL,
yes, Your Lordship,
whether report was received.
it was received, Your Lordship.
number?
Therefore, supplementary charge sheet was filed, which is at page number 33, Your Lordship.
Where is the report of the FSL?
Page number 35.
Yes. Any other point?
Yes, Your Lordship. Your Lordship, I'll just won't go through the entire PW statement. However, some of the important prosecution witness that I would like to go through is PW1, which is page number 40, Your Lordship.
Yes.
Your Lordship will Your Lordship go through the statement. The victim, he had directly called up this PW1, who is the brother of the victim, Your Lordship, and also told him through phone that he was shot by the accused, Your Lordship. And thereafter, he was immediately taken to the hospital, Miao, where the doctor has stated that the treatment is not available in CHC Miao, and therefore he was transferred to Tinsukia, then to Dibrugarh, Your Lordship. Meanwhile, therefore, the complaint was filed by the sister, who might have not seen the incident or nothing. He was just informed by the PW1 as well as the victim to file a complaint, Your Lordship. Your Lordship, at page number 41, we'll see that the cross, Your Lordship.
Yes.
If I may read, Your Lordship. When my elder brother Rabindra Chakma was shot, I was present at my residence, which is situated at about 6 kilometer distance. I have not seen who has fired upon Rabindra Chakma. I was told by Rabindra Chakma that during the time of firing, no one has seen, but everyone has heard the firing. I do not know if there was any enmity between Rabindra Chakma and accused. Before Bhakta Chakma confessed before police that Rabindra Chakma was fired, I did not know about the same. So this PW was informed by the victim himself, Your Lordship. Now, if I may take Your Lordship to the statement of the victim, Your Lordship, which is at page number 43.
Yes.
While corroborating, he states that I know the accused person standing on the dock. His name is Bhakta. He's to reside near my agriculture field. I have no enmity with him. During evening at about 5:30 p.m. of 27 December last year, accused Bhakta had shot me with a gun. During the time I was going back to my home, and he fired upon me near my compound. Pellet hits me on my back, waist, and shoulder. When I sustained injury, I fell down. I was shouting for help. I have seen Bhakta running away towards agriculture field, holding a gun on his hand. Hearing my sound, my wife came near to me. I have told her that Bhakta fired me with a gun. Thereafter, my brother took me to CHC Miao, but as my injury was serious, I was referred to Margarita Hospital. Thereafter, I was again referred to hospital at Dibrugarh for my treatment. At Dibrugarh, I was operated and 3 pellets are taken out from my body. But one of the pellet who hit on the lower back of my body is stuck inside my backbone, which could not be taken out till date. Due to the bullet injury, I cannot walk or stand. Now I'm lying on bed as lower part of my body got paralyzed. Your Lordship will see the cross. I have seen Bhakta on the place of occurrence with the gun on his hand. I was fired from back. After I was fired, I've seen Bhakta, Your Lordship. In his statement, he clearly stated that there was no one around. After he was shot in the back, when he looked back, it was only a person, the accused, with the gun, Your Lordship. Now, if I may take Your Lordship to the The Caesar witnesses, Your Lordship, at page number 46.
Yes.
PW6, Your Lordship. Police has seized one SBML gun in my presence. As per instruction of the police officer, I put my signature as witness of this seizure. I've also put my signature on police station on another memo. The second seizure witness is PW8 at page number 48, Your Lordship.
Yes.
I know the accused person standing on the dock is Bhakta. I do not know about the case. One SBL ML gun belongs to Bhakta was recovered by police from Bamboo Grove. So and so. So he was also, and he confirms that this the gun belongs to the accused, Your Lordship. Now, Your Lordship will also know that during the process, Your Lordship, one Hakim Chakma, who is the brother-in-law of the accused, has also produced one local-made gun, Your Lordship, before the police on the statement of the accused, Your Lordship. And that was also seized, and therefore, the Arms Act 27(1) and 25(1)A was also put along in the charge, Your Lordship. The two witnesses who has witnessed the seizure of that another gun is of PW14, Your Lordship.
Page number.
Page number, Your Lordship will find at page number 56. Yes.
Yes.
One day, police personnel recovered 2 Kanja Banduk from our village. I was called to police station to sign the seizure memo as witness. Accordingly, I signed the seizure memo. I cannot recognize the gun, Your Lordship. The second witness is at page number 57, PW15, Your Lordship.
Yes.
One Hatke Chakma is my friend. He purchased one muzzle loading gun from someone. He was called by the office in charge of Mia PS. He asked me to accompany to the PS as he did not have any vehicle. Accordingly, I took him to Mia PS. He took one muzzle loading gun for depositing at the PS. Along with us, one Mangal Ladan also went to PS. At PS, I was asked to be the witness of the seizure muzzle loading gun. Accordingly, I put my thumb impression on the seizure. These two witnesses are the seizure witnesses of the another gun which was surrendered by PW5. If I may take Your Lordship to PW5 statement, Your Lordship, which is at page number 45.
Yes.
Your Lordship, I know the accused person standing on the dock. His name is Bhakta. He is my brother-in-law. Before about 10 months from today, one day at about 3 p.m., Bhakta Chakma came to our residence. Since I was to go to my native village for attendance of work, I went away. I'm reading the wrong. Yes, Your Lordship.
It is correct, my lord. The Hichi Chakma was cross-examined twice. He deposed before the court twice.
But sir.
Page 45 and page 59.
Okay.
59. And his cross-examination
Yes.
was declined.
Yes. Page 59, Your Lordship. Twice he was called for, Your Lordship.
On the same day.
If I may read, Your Lordship. I know the accused person standing on the dock. His name is Bhakta. Bhakta used to make Kaja Bonduk SBML gun. Once I had purchased one SBML gun from Bhakta for an amount of rupees 800. After about 1 month of my purchase of the gun, Bhakta has fired upon Ravindra. During that time, I was in jungle for cutting timber. Bhakta was arrested by the police where he disclosed about selling a gun to me. Police and Bhakta came to our residence in search of SBML gun. When I came back, my wife told me about the incident. Accordingly, I produced the SBL gun before the police station. And the seizure of that gun is at page number, Your Lordship will find. Page number 12, Your Lordship.
Yes.
Seizure, name and particular of the person from whose possession the articles have been seized, Your Lordship, is the PW5, Your Lordship. he also, the PW5 also discloses that the local made gun was being manufactured by the accused, Your Lordship, and therefore the Arms Act to Your Lordship. Now, coming to the fact of the case, Your Lordship, will see that no one has seen the incident, Your Lordship. Some of the prosecution witness has heard the gunshot and they immediately came out of their house. And when they saw the victim, Your Lordship, victim has stated before everyone, before the prosecution witnesses, that he was shot by the accused, Your Lordship. Now, there was no question as to if during that time there was light or not, if it was dark or not. That is not a subject matter in this matter, Your Lordship. The other point, Your Lordship has already made it clear that even the record clearly states that he was being he was given the legal aid, Your Lordship, who was also present during the framing of charge as well as during the entire trial, Your Lordship. Yes, Your Lordship, I'll leave to my defense.
My lord, just one thing I would like to point out.
Yes.
My lord, if your lordship sees the evidence of PW8 at page 48, who is one of the Caesar witnesses,
Yes.
he says that police has, I know accused person standing on the dock, he is Bhakta. I do not know about the case. One SBI gun belongs to Bhakta was recovered by police from Bamboo Grove. Now, material exhibit 1 is the seized gun. Now, your lordship, come to page 59. This person, Kichi Chakma, has deposed twice before the court on the same day.
Yes.
The second last line of his deposition, material exhibit 1 is the SBML gun I have purchased from Bhakta Chakma. Now, my friend is referring to page 11 of the Caesar memo. Yes, 12, Caesar memo. Here also, nothing has come out from this. In fact, there should be then 3 material exhibits. Already from the Caesar recovery memo, police has recovered 1, and that is material exhibit number 1. Material exhibit number 1. The other one is given by the PW5 at page 59 and
Exhibit 51.
page 46, the other
Exhibit 3.
Caesar witnesses in whose presence gun was recovered. Material exhibit 2 is the SBML gun which was seized by police in my presence.
Yes.
So there are some contradictions in the prosecution witnesses, and moreover the legal aid counsel has not properly done the cross-examination of the witnesses, and not as per the guidelines given by the Anokilal case and as well as the recent judgment of the Supreme Court in Ashok versus State of Uttar Pradesh manner. So this is a case where this honorable court may be pleased to acquit the accused person.
Okay.
Your Honor. Your Lordship, I'm appearing on behalf of the victim.
Behalf of the victim.
Yes.
Yes. You want to submit something?
Yes, Your Lordship.
Yes.
This whole appeal, the incident that happens, it happened on a 28/12 night as 27, 28 December.
as the Learned Defense Council has stated, as well as the PP has stated, that it was December 9. The incident happens between 5 to 6 p.m. In the FIR itself, the FIR is written by the brother, not the victim. Then in the FIR, they state that regarding the light not being able to see, that's why I'm putting this. It says that it's an agricultural land in the paddy field, and it's December, which means the paddy fields were cut, and the house is nearby, because when the victim screams, his hue and cry was heard by his wife and the other people also. Leave aside the gunshot, even if if it was in the jungle, it could have been heard. But his hue and cry could be heard, which means the houses are nearby. And they come from the same village and they are situated in the same place. So to say that there was not a single eyewitness would be wrong, because the victim himself is the eyewitness. He's the ocular witness here, because he turns back, he's been shot from back. Then they're being emphasizing on these two seizures that had been taken. One is the disclosure memo, and the other is 2 guns were seized. One was to ascertain whether the accused was manufacturing the local gun or not, which is dependent on the PW of the Hichik Chakma, who has been, they say that he has been, his PWs was taken twice. The relevant part of his being taken twice, that I'm not understanding, but the main crux that we have to take out of his was only to ascertain whether that guns was made by him or not. Then he says in the boat that I have purchased the gun from this accused person. So that is 27, Arms Act is covered. Now the disclosure statement is given by, disclosure is what? Disclosure has to be given by the accused himself, and then it leads to the recovery of the offense, the weapon of offense. So here it is done, because if your lordships will go through that, the recovery was disclosure was done, recovery was taken, the weapon of offense was taken, and then it was sent to FSL expert, and wherein it was seen that this was a gun which was made illegally. 27 is covered, and it's the same gun, it was given in the FSL. Here we see that the Learned Defense Council had given 14 grounds, but today in this 14 grounds, he has nowhere mentioned about the LAC, and that it is because of the weakness of the advocate that he has been, this life imprisonment has he has been convicted. In it is nowhere covered in the 14 grounds that he has put forward. Although he has said that not proven beyond reasonable doubt, no eyewitness, then based on circumstantial evidence. Yes, this is based other than the ocular witness, yes. But we will have to see whether the chain rounds up or not, whether it has been, the accused has been beyond reasonable doubt or not. In this case, it has been proven beyond reasonable doubt, because in the 161 of his own wife, what could have been the motive? They didn't emphasize on the motive, although. What could have been the motive? If your lordship will go to
Madam, if we consider the victim as eyewitness to the occurrence,
Yes.
then motive is irrelevant.
Pardon?
If we consider the victim as eyewitness,
Yes.
then the motive is irrelevant.
Motive is, yes, irrelevant. Otherwise also, yes. Then I don't need to go into that. Then otherwise also, the wife, accuser's wife also. The wife, what's that page? Sorry. Accused the wife of David. 51. Srimati was. She says that.
Page number?
50.
No, this is the wife of the accused. Page number 49. Page number 49. Your Lordship, page number 49. In her cross, she states that the last four lines, it is a fact that on the date of occurrence, I, along with Bhakta, went to the residence of Anil Chakma at Nyotan village. It is a fact that at around 4:30 p.m., Anil Chakma went to the village to collect money. It is a fact that after some time, my husband also went away from the residence. After about 2 to 3 hours, Bhakta came back to the residence of Anil Chakma. The 2 to 3 hours is the time when the incident happens, and the defense is unable to produce any alibi. She says that they were in the place of Anil Chakma 4:30 p.m. Chak went to the village to collect money. It is a fact that after some time, my husband, that is the accused person, also went away from the residence. After about 2 to 3 hours, Bhakta came back to the residence of Anil Chakma. We stayed for the night at the residence of Anil Chakma, and next day morning, we returned to our village, to the residence. Later on, I have heard that my husband, Bhakta. So the 2 hours that the wife has stated, that is the time when the incident happens, and the defense is unable to show any alibi. So basing on that, also the circumstantial evidence is it comes to a whole chain of evidence that here the accused is proven beyond reasonable doubt. And also, I would like to put before the lordships that the victim, his present day, because of this incident, he is half paralyzed. Till day, for his daily chores, is dependent on other people. So according to my understanding, this conviction has to be upheld. So
Heard Mr. Edhor, learned counsel for the appellant. And Ms. Tejini, learned additional PP for the state respondent number 1. And Madam,
I'm SV Daram,
SV?
LSC. SV Daram, LSC.
learned counsel
For the
for the
victim.
respondent number 2. Argument concluded, judgment reserved.
Obliged, my lord.
Bye.
My lord.
Whether any counter affidavit has been filed?
Well, this is a writ appeal, my lord. Writ appeal against the judgment passed by the single judge.
That's all right, but you see
Yes, ma'am.
the last order. 28/5/2024.
My lord.
The respondents are at liberty to bring their respective stand on record by filing affidavit if so advised. Mr. Roton,
Yes, my lord.
have you filed your affidavit?
No, my lord.
Not required.
Not filed.
Not filed or not required?
We have filed our affidavit in the writ petition, my lord.
Main petition.
Yes, my lord. But today I was searching for one of our manual, which was supposed to be in the file. It's not there. That vigilance clearance manual, the latest one.
Everything is here. But
No, there is.
it is the combination of that all the impugn orders.
Hmm. So without that manual, you are handicapped.
No, my lord, it will depend on his argument, my lord. Otherwise,
That's
Because,
all right, but are you ready to argue the matter today?
Yes, ma'am. Yes.
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 can it be some other day?
No, we are ready to hear.
I pray one of this matter may be disposed of because of the pendency of this writ petition or writ appeal, my lord, I'm also going to retire, my lord.
When?
My lord, my age is, my lord, now my age is 57 or 58 something, my lord, my age.
So 3 years.
Well,
You have to go.
for the last 36 years, I have not been given any promotion, my lord.
So, my lord,
Hang on, who's there?
Have you left the land or you are still occupying?
yes, sir, I'm there.
You're there.
Yes, sir.
You should be continuing like this for some time.
Well, there, my lord, actually, I have been allowed by the district administration. If my lord may see,
You had applied, but you have not been given a settlement of that.
yes, my lord.
That is government.
But
The requirement is it's only supplementing, not supplanting. That's the finding of the learned single judge.
yes, my
What is the error?
lord, fine, I will go on the facts then.
What is
Facts.
the error? You just tell us on the error.
Yes, yes, sir. Yes, my lord. Error, my lord,
Yes, sir. If you want to have it today, we'll have it on some other day.
I'll request if we can have it on some other day. Otherwise, it's you should have challenged the notification itself, but not by this way, my lord.
petition, does it carry any statutory force, my lord? That has to be seen, my lord.
Executive order.
Yes, my lord.
Supplementary.
Supplementary, my lord, I will, my lord, on the facts of my case, my lord, whether it is applicable or not, my lord. On one statement, page 87, my lord. This is the first impugn order, my lord. 2 April 2013, my lord. My lord, may I please come to page para 3, my lord. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance to government officials for promotion, my lord. I am for promotion, my lord. And settling of retirement due, NOC shall be obtained. NOC is for, my lord, for a pensioner, my lord. I am for promotion, my lord. My lord, may I kindly appreciate the paragraph. It has been decided that vigilance clearance to government officials for promotion and for settling retirement due, NOC shall be obtained. So, my lord, I am from the first part, my lord. Vigilance clearance, my lord. Now, vigilance clearance, my lord, this is of 2013, my lord, subsequently page 88, my lord. Well, this also this circular, sir. Can it be retrospectively, my lord, applied, my lord? That would also be my case. Sir. Again, para 3, my lord. Same thing, my lord. Page 88, my lord. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance to government officials for promotion, my lord. And for settling retirement due, NOC shall be obtained. Now, my lord, what happened? There was a vacancy. This is of 2000, my lord. Let's see, this impugn order is of, first impugn order is of 2 April 2013, my lord. Second is of 6/6/2017, my lord. Now comes the vacancy, my lord. My lord, may I please come to page 100, my lord. The vacancy arose in the year 2 February 2017, my lord. This is the vacancy, my lord. I am at serial number, my lord, 57, my lord. Now, my lord, this my DA4, my lord, page 11, my lord, 111, page 111, my lord. My DA4 seek NOC cum vigilance clearance from the deputy commissioner. Now, deputy commissioner has also issued an vigilance clearance certificate, my lord, but in a, my lord, other way, page 127, my lord.
Oh, whether deputy commissioner is authorized,
Yes, my lord, as per the circular, my lord,
which one?
as per the impugn orders, my lord. Page 127, my lord.
One?
127, my lord.
Yes.
My lord. On the top, my lord, Government of Arunachal Pradesh, Office of the Deputy Commissioner, District Vigilance Officer. My lord. Now this officer, my lord, is exercising the power of, my lord, vigilance officer. Now he issues a certificate in my favor.
This is to certify that Sri Netan Singh, forester, care of so and so, so and so, and so, has constructed a private building on a plot of government land at Bondila. Although he did not possess any formal land allotment order, the official records reveals that he has obtained permission from the office of the Deputy Commissioner, West Kameng District, for carrying out the construction works of the said building, my lord. So there was a vigilance certificate, my lord, but I was never considered, my lord.
You are?
Never considered for promotion, my lord. This is a certificate given by the vigilance, my lord. District Vigilance Officer. By this certificate, my lord, I am not an unauthorized occupied, my lord. There is a permission, my lord, from the district administration, my lord. Even, my lord, section 309 itself says, my lord. Am I correct or not, my lord? But section 309, my lord. It starts, my lord. It starts with the opening, my lord, words, subject to the provisions of the Constitution, my lord. So I should be treated equally with the private individuals, my lord. Article 14 will prevail, my lord.
Oh, where is the certificate issued by the Deputy Commissioner?
Page 127, my lord. 127, my lord. 127, my lord.
So whether the Deputy Commissioner can grant such permission?
Yes, my lord. As per this impute orders, my lord. This is of 2017, my lord.
No. Obtain permission from the office of the Deputy Commissioner for carrying out construction work of the said building.
My lord, I had applied for allotment of land in the year 1998, my lord. Now my allotment was under consideration, my lord. So why I started, my lord, construction of work. Then a notice was issued, and upon that, my lord, I submitted a representation, my lord, and then they gave me to submit one. They asked me to submit one undertaking. I submitted my undertaking, my lord, of rupees 2,000 in the year 1998, my lord. Now, after that, they have given us the permission, my lord. The permission would be at page number, my lord. 125, my lord. Yes, my lord. 123, my lord, I have submitted it through Chalan, my lord. Through Treasury Chalan, my lord. 125 is the, my lord, my
So, Doctor, if 127 is already there, page 127,
Yes, my lord.
then what is the bar?
My lord will kindly see 116, my lord.
I've seen it, that proceedings against undertaking given by.
No, my lord, 116. This is a earlier notice.
That notice then
It has been brought to the notice of the understanding that you are constructing building on RCC building unauthorizedly on government land defined our earlier notices. So you are hereby directed to stop construction with immediate effect and hand over the tools and implements and materials to the official of the land management. This was there. Then permission has been sought, my lord.
125.
118. This is of 1998. That time also he was stopped.
But subsequently,
Yes, my lord will see his permission for reconstruction of accessible. Yes, ma'am.
912. Now you come down to page 125. Same day, some Lotmondal had given him permission. Yes.
Yes,
ESC.
for deputy commissioner.
So he said that you are allowed to continue.
Yes.
But you
My lord.
deposit the amount.
Yes, my lord.
So have you deposited this amount?
Yes, my lord.
That is the
2000
first installment, 2,000. Balance.
balance, my lord, this 2000 is the amount because my lord, this says, my lord,
You come to page 120,
122. Yes, my lord.
second paragraph. I have
Yes.
paid 2,000 only as first installment.
Mm.
And I undertake the rest amount will be paid after formal approval. And I may be currently issued a construction order against my.
Formal approval work at that point of time, I have filed and I have applied in land allotment, my lord. Now, date has been misplaced by the authorities. Then I subsequently filed in the year 2016 this application, my lord, for allotment of land, my lord.
So your case is that you have the clear,
I have no criminal case, my lord.
no, you have clear cut NOC from the deputy commissioner.
Yes, my lord.
Yes, you sir.
My lord, the NOC as required by the circular of the vigilance department. This is not an NOC as such, my lord, at page 127, my lord. It is just saying permission was given, but
Permission was given, the NOC is only required to show that he is not illegally.
Yes.
If he is a permissible occupant, why are you?
my
blocking him?
lord, in fact, he has sought permission to start construction. That ESC LM who has given the permission, whether he was the authority to give that
Where is
permission.
those materials that these were documents before the Lalan Singhal Sardini affidavit, have you dealt with this?
My lord, this because they have not made party to this, my lord. We have only the filed affidavit on behalf of the vigilance clearance. We have said there is no vigilance clearance. What I fear is it might be taken up as a precedence, my lordship's decision, any decision, giving a slight relief. It might take be a binding precedent, take as a precedence for others also.
No, it cannot be a ground, my lord. I can cite one
Because-
judgment.
So according to you, this page number 127 is not in accordance with the vigilance manual.
Yes,
You produce the vigilance manual before the court then.
direct NOC has to be given. There is no land encroachment.
Where is the application filed by you
For my lord,
for NOC?
NOC, yes, my lord. That would be it. It was routed first through the department, my lord. May I please come to page 111, 111, my lord. This is the DFO, Divisional Forest Officer, my lord, has communicated to the Deputy Commissioner seeking NOC cum vigilance clearance on 24 February 2017, my lord.
Nothing was given in person.
My lord. Subsequently, my lord, that page 125, my lord. That NOC, my lord.
Not, that is not addressed to this.
And then, my lord, page 113, my lord, to the Deputy Commissioner.
And then
13, my lord, my representation, my lord. Here I have My lord, annex the entire background of the facts, my lord. Pursuant to that, my lord. Pursuant to that, page 127 came into existence.
So, Mr. Ratan,
Yes,
you do one thing, you produce the vigilance manual. We'll see.
Yes, ma'am.
Is it available before the court? Manual?
No, my lord.
No.
No, my lord. But this is this vigilance manual, my lord.
Or-
This is the amalgamation of all
Because-
the impugn orders, my lord.
Or my lord, may direct Deputy Commissioner to file an affidavit directly. Because
No, no.
Deputy
We are
Commissioner was
sitting
not
in
made a
appeal.
party. And the NOC relied on by my learned friend is not a correspondence to the authority who has sought the NOC.
No, no,
The-
Mr. Ratan,
Department has sought, yes, ma'am.
we are sitting in appeal.
Yes, ma'am.
So do we direct the deputy commissioner?
That's why I was. I'll produce the record and what's on the appeal and on the basis of the findings of the learned single judge, that whether my lords will upheld it or
Okay, next week then.
next. Mr.
First week of January then.
My lord.
Huh?
My lord.
Or Mr. B. Tisal, learned counsel for the appellant, and Mr. Ratan for the respondent. List the matter in the first week of January, so as to enable Mr. Ratan to produce the vigilance manual
Yes, ma'am.
before this court on next week.
Ma'am, yes. Oblige, ma'am.
Oblige.
Petition dismissed, but respondent number 2 is directed for posting of the petitioner in a branch of his office where workload is minimal.
My lord, my lord, I beg to mention, my lord, at number 28, my lord, it's a part hard matter, my lord. It won't take much time. May I pray, my lord, can this be taken after motion? I think, my lord. My part done, my lord.
Okay.
Deeply obliged, my lord.
My lord, item number 19. My lord, just now I received a copy of the affidavit in opposition from the respondent side. So, my lord, I may be given 2 weeks time to file the counter, man.
Okay.
19, item number 19.
Mr. T. Son, learned counsel for the petitioner. You inform the other side.
Well, he was in Tagum, standing counsel for the medical department.
Item number 19. With consent from the other side, pays for listing the matter after 3 weeks.
2 weeks.
2 weeks.
Yeah.
So as to enable him to file counter affidavit.
I file counter affidavit today, my lord.
No,
Yes.
file a reply to the counter affidavit. Okay. There, Lord.
Deeply.
Obliged, Lord.
May I, Lordship? Lordship, I beg to mention item number 10 on the behalf of T. Sune for respondent number 3. Due to some medical issue, he cannot appear here today. So the matter may be kindly list after vacation. Any
After
date.
vacation.
My lord, I'm the petitioners, my lord. This matter may be fixed on 27 of January 2025.
27 January.
Yes.
Okay. As agreed by learned advocates of the parties, we shall list the matter on 27th of January 2025.
May I, Lordship? Lordship, I would like to mention item number 7, 8, 9, Lordship. This is with matter, Lordship. Lordship, this matter may be list after 2 weeks, Lordships. I inform all the parties, Lordships.
Mr. G. Bab, learned counsel for the, you for the,
I am in item number, Lordship, 7 and 9, Lordship. I am for the petitioner, Lordship. And item
learned
number
counsel
8,
for the
Lordship,
petitioner with consent from the other side, press for listening the matter after,
after 2 weeks, Lordship.
after 2 weeks. And in item number 8,
8, Lordship, I am not here, Lordship. But, Lordship, this is with matter, Lordships. Connected matter, Lordship. I inform the parties, Lordship. Much of it.
Lordship, I beg to mention one pending matter to be listed tomorrow for withdrawal.
My lord, even on the last occasion, my lord, records were called for, my lord. Whether the second revised list was issued by the deputy commissioner or not, my lord. And regarding the, my lord, not allowing me to participate in the walking interview, my lord, for the dental surgeon, my lord. Well, initially, my lord, there was a list, my lord, published by the Office of Deputy Commissioner, my lord, who is the chairman, my lord. My name does not appear on that list, my lord. So I requested the deputy commissioner, and subsequently in the second list, my name was, my lord, shown
Appeared.
as a roll
your
number
name
30 appeared, my lord. Now, on that day, my lord, my friend, my lord, had submitted that, my lord. It was not signed, my lord, by the deputy commissioner, my lord. The second list, my lord. For that, my lord, record was called for, my lord.
yes, Mr.
Lordship, record has come as Lordship submitted on last occasion. The corrigendum, Lordship, proposed corrigendum that's appear at page 39, Lordship. Down below, Lordship will find there's no signature of the deputy commissioner, Lordship. No signature of deputy commissioner. So reason on that day, just I have apprised this honorable court, Lordship, because the application was not received in time, Lordship. Application was supposed to be filed on or before 13th of Lordship this month, Lordship. But the applications of the petitioner, it reached in the office only on 14th. So there was a proposed from the, when application came, then there was a proposed whether it has to be allowed or not, Lordship. Then it was not allowed.
Allowed.
Not allowed.
He was not allowed to appear.
Not allowed, not included as a candidate, Lordship.
And this annexure 4 is not.
Not issued. It was never issued, Lordship. But proposal was there since application was before 10 months. The entire process is there, Lordship. Records is here, Lordship.
So annexure 4 was not issued by.
Never issued.
Deputy commissioner.
Never issued.
But he said that my proposal was considered, my lord, but it was rejected.
It was when application was processed, Lordship. The Babu Lordship processed it before the Lordship higher authority, and it was rejected because it was submitted, Lordship, after the stipulated date, Lordship.
But my lord, this annexure 4 has been provided to us, my lord, by the office itself, my lord.
This is very, Lordship.
We have the bona fide impression that, my lord, my application was considered. Accordingly, this, my lord, corrigendum has been issued, my lord.
Otherwise,
No,
Lordship.
if this was not issued by the deputy commissioner, then. This is a serious matter.
In that case, my lord, my friend may submit me, my lord, furnish me a copy of the rejection order, my lord. I may approach this court, my lord, by filing a fresh petition, challenging that, my lord, decision. Because
Any order was passed rejecting his application?
No, Lordship. That's done in, Lordship, the order sheet only.
Order sheet is available.
Otherwise, Lordship, this matter can be disposed of as proposed by my senior friend on past day, Lordship. Since his application is pending before the lawsuit authority, then authority will pass appropriate order on that lawsuit and copy will be furnished to him. And if he feel agreed, then he can challenge that order.
Yes, madam, that can be also personal.
And even his application also is here in original laws. There also, it has been annexed as annexure lawsuit 2 also. There also lawsuit will not find his date in his signature lawsuit, the petitioner's signature lawsuit. His original application is here without bearing date also. And all the lawsuit, the supporting documents, self attestation is their lawsuit, but doesn't bear any date lawsuit. Anyway, in that, as proposed by my senior friend, in that line, if it's disposed of the lawsuit, I have no objection. That can be.
Whenever filed a representation,
18 November 2024, madam.
1811.
Page 4040 lawsuit.
Type copy is page 41 only.
Heard Mr. Arsokia, learned counsel for the petitioner, and Mr. S. Topin, learned senior government advocate for the respondent number 2. And Mr. Tagum for respondent number 1, 3, and 4.
1, 2, 3, and 4.
Person to order dated 3/12/2024. Mr. S. Topin, learned senior government advocate, has produced the relevant file before this court.
Sir.
Relevant file relating to selection process. And Mr. Topin submits that exhibit annexure 5, annexure 4, which is enclosed with the petition, was never issued by the respondent number 2. Issued by the office of the respondent number 2. At this stage, Mr. Soikia, learned counsel for the petitioner, submits that the petitioner has submitted one representation before the respondent number 2 on 18/11/2024. And the said representation is yet to be disposed of. And as such, this repetition may be disposed of by directing the respondent number 2 to dispose of the petition, no, dispose of the representation of the petitioner within a period of 1 week from the date of receipt of certified copy. It is to be noted here that the petitioner, being a graduate, being a graduate of Bachelor of Dental Surgeon from Dr. Bhimrao Ambedkar University, Agra, had applied for the post of dental surgeon under National Oral Health Program on contractual basis, pursuant to the advertisement issued on 30/10/2024 by the Deputy Commissioner cum Chairman National Oral Health Mission, Sanglang District, Arunachal Pradesh. Then pursuant to the said advertisement, the petitioner has submitted his application and he was called for the interview, walk-in interview on 14/11/2024. But he was not allowed to participate in the selection process. Not allowed to appear in the interview. In the interview, though his name was published by corrigendum dated 14 November 2024, Annexure 4 of the petition. But having considered the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the respondent number 2, the Deputy Commissioner cum Chairman, National Oral Health Mission, to dispose of the representation of the petitioner within a period of 1 week from the date of receipt of representation, the receipt of certified copy of this order, by passing a revision order in terms of this petition is disposed of at this motion is itself. The petitioner shall obtain a certificate of this order and produce the same before the amendment number 2 within a period of 3 days from today.
Yes, I mean, last occasion, the instruction was seeking whether my suspension order, my lord, was a review or not, my lord.
Yes.
My lord, admittedly, my lord, no review was done, my lord. No review has been done.
Then what to do?
Well, in that
Decision of Supreme Court in Ojai Soda.
my lord, it will prevail, my lord.
My lord will interpret, my lord. I have series of judgment, Supreme Court and this court also, my lord. In such a thing. By directing me to reinstate.
Proceeding will remain as it is, but suspension part, my lord.
Suspension order will be set aside.
Right.
We'll pass the order. You produce the judgment.
Right.
We consequential direction to reinstate me.
Pardon?
Consequential direction to reinstate me, my lord, by setting aside.
Prosecution?
Direction to reinstate me, my lord, in the service. Consequential direction. After setting aside the, my lord, impugn order, my lord.
It is automatically there, my lord. Once suspension lapses, my lord.
That Ojai Soda decision is there. Okay. Next item.
Obviously.
Marvelous, my lord. So, my lord, I have enacted this, which the order in the CRP number 54, which could not annex on the last of while filing inadvertently. So whether this is before that I have filed this morning, and this should be in the whether before the my lord or not.
Additional affidavit.
Additional affidavit.
When?
This morning. So that
It is not available. In the morning, you could have mentioned the method and we could have called it from the section. We'll take it up at 2 o'clock. In the meantime, call for the affidavit.
all right. My lord, the petitioners, they are casual laborers working under the executive engineer, electrical division SEPA,
In which department?
electrical division SEPA, madam.
Electric.
Power department. Power.
Who is for the state, who is for the respondents?
This is notice maybe go, my lord.
Notice.
My lord.
My lord, I have interim prayer.
Interim period?
Interim prayer, my lord. My service, our services will be protected, my lord. During the pendency of this matter, our services should not be disturbed, my lord. Because
Not
not our services should not be disturbed. because we are casual labor. We may be terminated at any time, my lord. So I need protection of this honorable court, my lord.
How the general order can be passed in this, my lord? Their case here is a UK paper equivalent, my lord.
If
There
we
will
are
be-
not protected, my lord, if we are terminated, then this matter will become impractical, my lord.
No,
So
they-
we need protection because we may be terminated at any time.
No, they are contractual laborer.
My lord,
Casual laborers.
how the general order can
Casual.
pass in this case?
Heard Mr. S. Goyan, learned counsel for the petitioner, and Mr. L. Parnell, learned counsel for the respondent authorities. For all the respondents,
My lord.
in this petition, under Article 226 of the Constitution of India, 45 petitioners tried for issuing direction to the respondent authorities for payment of salary equal to the salary of regular employees of the same cadre and other service benefits. Mr. Goyang, learned counsel for the petitioner, submits that the petitioners are casual laborer working in different posts, namely operator, lineman, peon, wireman, meter reader, driver, handyman, electrician, etc. under the executive engineer SEPA electrical division for last 30 years. And they're being paid monthly salary at the rate of rupees 12,000.
This
Which
is
is not
initial pay.
sufficient to.
This is initial pay, my lord. 12,000 in initial pay. At the time of joining this in the service.
At the time of joining. Now, what is the salary you are drawing?
My lord, the different petitioners are getting different salary. Some of them, they have served more than 30 years. They are getting 18,000. And those who have joined last 2-3 years, they are getting lesser salary, my lord. Initial salary is 12,000.
And the amount and the salary they have been receiving is not sufficient to manage education for their children and food and clothes for their family members, and also to pay rent, electricity bill, water bill, etc. And they have not been provided any benefits like a regular government employees, like casual leave, earned leave, government quarter pension and service benefit, etc. And that in view of the decision of Honorable Supreme Court in the case of Uma Devi, which is packet 3 and others, reported in 2006, OSCC, page number 1, and also in the case of State of Punjab and others versus Jagjit Singh and others, reported in 2017, 1 SCC 148. they are also, the petitioners are also entitled to draw wages at the minimum of the pay scale at the lowest cadre, at the lowest grade in the regular pay scale, extended to regular employees holding the same post. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued. As Mr. L. Parme, learned counsel for the petitioner, appears and receive notice, however, extra requisite copy of the petition will be furnished to him during the course of the day. Less the matter after 4 weeks, interim care of the petitioner will be considered on next date.
My lord,
You file.
my lord, if I am not granted interim relief, my service is in danger, my lord. Because as per appointment,
You are serving for 30 years.
no, some of them are they are serving for 10 years, my lord. The different petitioners have served different period of time.
Let him file affidavit. We'll see.
My lord, till next hearing, please
No.
grant me interim relief, my lord.
No.
Well, this will become infructuous
No,
if
no,
I am
no,
if
make-
I am terminated, my lord.
For 2 weeks, then you file affidavit.
My lord, he is supposed to terminate there, it depend cause of action, my lord. His case is A, my lord, and he is seeking interim period for the cause of action for B, my lord. I'm extremely sorry, how that can be, my lord.
Okay, you file it. Affidavit. Next matter is also same.
My lord, yes, same
Okay.
matter. My lord, in the next hearing, the interim period may be considered. That may
That's
be
why I have dictated it.
obligatory.
But last occasion, my part was done, and it's for respondent, my lord. After there's some, I'll just add certain additional points subject to their, my lord, submission.
Yes, Mr. Tapin.
Here I have a very limited submission, Lordship.
Pardon?
Very limited submission from my
Limited
side, Lordship. Because since the recruitment was conducted by Lordship, Arunachal Pradesh Public Service Commission, Lordship, which is being represented by my senior Lordship. If Lordship say the advertisement itself, Lordship, advertisement is at page 5050, Lordship, read petition.
Page number?
Page 5050, Lordship, annexure 5 series.
Yes.
Possible find in the advertisement number of posts from which department everything are given, and so far this physically handicapped Lordship candidates are concerned. For them also, Lordship, how many numbers of vacancies are there is stipulated, Lordship. And if the education qualification also is same for everyone, Lordship. If Lordship turn to next page, Lordship will find at serial number 5. The method of selection, Lordship. Eligible candidates will have to appear in written examination in the following subject, followed by interview to be conducted by Arunachal Pradesh Public Service Commission, on the basis of which selection will be finalized. The compulsory and this the English general and after Lordship, this very column, Lordship, the number of candidates. The number of candidates who shall be called for personal test biography interview will be in the ratio of 1:3. It's given in the Lordship. That is 3 candidates for 1 post as per merit in written examination, subject to securing a minimum.
What was the what is the number of the posts meant for the physical handicapped persons?
5 posts. 5.
5.
5 posts.
So against the 5 posts, you ought to have called 15 then,
Lordship.
15 candidates.
Lordship. Now, what I'm Lordship trying to submit is the Lordship. As per the Lordship, Lordship, that should have been done, Lordship. But in advertisement itself, the what criteria has to be followed by the authority, recruiting authority. That has been stipulated here, Lordship. And knowing fully the petitioner has participated, Lordship. Knowing this provision, he has participated, Lordship. What it says, Lordship? The number of candidates who shall be called for personal test, biopsy, interview will be in the ratio of 1:3.
He participated without any objection.
Without any objection. And 3 candidates for 1 post as per merit in written examination, subject to securing a minimum of 33% or more marks in each written papers and 45% or more marks in aggregate out of the total marks in the written examinations. And so far, this ratio is Lordship concern, Lordship. This ratio is not meant for particular category, Lordship. This is the combined examination, Lordship. Combined examination, Lordship, this examination is conducted against the total post, total vacant post, whatever requisitions was before the Lordship, Honorable Parties Public Service Commission, Lordship. And in respect of all the Lordship vacant posts, this particular combined examination has been conducted, Lordship. Combined examination. This is not for this category and that category, Lordship. But among these total requisited post, Lordship, certain posts are meant for this particular category. That is their Lordship. But what has been stipulated as a terms and condition, Lordship, from the retained Lordship, the total Lordship, those who are qualified as per the merit, Lordship, 1:3 will be called for interview, Lordship. Who secure Lordship on merit? As per merit, Lordship, 1:3. If post is 1, Lordship, 3% candidates on merit would be called for interview, Lordship. That is the condition, Lordship. Exactly what had happened in this case, Lordship. In present case, Lordship, out of total post, Lordship, 180 candidate was called for. 180, Lordship. Then, Lordship, this particular condition has not been, Lordship, challenged by the petitioner. He knowingly participated, Lordship. He knew that, Lordship, out of total, Lordship, merit 1:3 ratio will be called for, Lordship. Not by, Lordship, segregating out of, Lordship, it will be selected among the, Lordship, physically handicapped Lordship candidates. That is not the stipulation in the advertisement itself, Lordship.
No, it may not be in the advertisement, but what is the law?
Lordship, therefore, Lordship, I am just trying to, Lordship, what advertisement says, Lordship. Because Supreme Court also on Lordship, some point it says law.
No, that's all right, but we have to keep in mind the statement, object, and region of the particular legislation.
Lordship. Then Lordship may take up my Lordship additional affidavit.
Additional affidavit. At page number?
Kindly come to page 3, Lordship.
Additional affidavit dated?
This is dated, Lordship, filed on 29/9/2022.
29/9.
Hearing was done on 28 September 2022. This is the additional affidavit by Lordship, respondent number 12. Respondent number 12.
12.
12. By respondent number 12.
12. Okay. 12 is here. Yes.
Kindly come to paragraph 4, Lordship.
Yes.
that the OM number so and so is always subject to the provisions of Act oblique rules. The rights of persons with disability Act 2016 and rules framed thereunder. That is Arunachal Pradesh rights of persons with disability rules 2018. Provides that the person with disability act selected on their own merit without relaxed standards along with other candidates will not be adjusted against the reserved share. But the vacancies in the reserved category shall be filled up separately from among the eligible candidates who are lower in merit than the last candidate in merit list, who is otherwise found suitable for appointment, if necessary by relaxed standard. And kindly come to page, Lordship, page 7. This is the Lordship Act.
Yes.
This is the Lordship Rights of Person with Disability Act 2016. And I'm taking Lordship to the Lordship page 10.
So these are draft rules.
No, it has been already notified, Lordship. It has been already
notified. Yes, page number 10.
This is from a Gazette only, Lordship. On the top, Lordship will find Arunachal Pradesh Gazette published on 14. This is the Arunachal Pradesh Rights of Person with Disability Act 2016, Lordship. And I'm taking Lordship to the page 10. On top, Lordship, person with disability selected on their own merit without relaxed standard along with other candidates will not be adjusted against the reserved share of the vacancies. On merit, Lordship, they will not be counted as a Lordship. Then provisional, Lordship, the reserved vacancies shall be filled up separately from among the eligible candidates who are lower in merit than the last candidate in the merit list, but otherwise found suitable for appointment if necessary by relaxed standard, Lordship. This is very clear, Lordship, for this particular category, Lordship. Selection has to be done from that very category, Lordship.
No, they will compete with the general category candidates. Whether they will compete with the general category candidates or they will compete among themselves.
It says, Lordship, they has to compete among themselves, Lordship, as per this very
rule
law.
Then whether your advertisement in accordance with rule?
Advertisement is not according to rules, Lordship.
Then,
Lordship, advertisement should have been challenged, Lordship. Therefore, this is the issue of technicality, Lordship. Because he has already complied the advertisement itself, Lordship. He gone with the advertisement, and now after participation, you are questioning that, Lordship. What I'm saying, this is the issue of technicality, Lordship. Otherwise, he would have challenged it prior to Lordship participation, Lordship. Your advertisement is not correct. It should have been as per the law. That should have been the Lordship. This is a technical issue, Lordship. And what this law says, Lordship, this should be, Lordship, among the Lordship, the same category, Lordship, the handicapped candidates, Lordship. But authority can fix, Lordship, the cut-off marks and all, Lordship. But that has to be among the, Lordship, this particular category, Lordship. Law is there, Lordship. So therefore, Lordship, I'm just making these two-fold submission, Lordship. One is what is law, other one is what had happened in present case, Lordship.
So admittedly, the advertisement is not in accordance with law.
Lordship, what I understood is that, Lordship, this particular ratio, because very clearly stipulation has been done, Lordship, how the selection will be done. 1:3 from the Lordship total Lordship merit list at a ratio of 1:3. And accordingly, it has been selected. And petitioner has participated. But when...
No, even then also,
Lordship,
he had secured 48%. Why he has not been called for the...
Therefore, in 1:3 ratio, he does not equal. He do not fall under the
category.
Because he gone beyond 180. Because the merit as per ratio has to be called as per the merit only, Lordship. But he do not fall under that 180 merit list, Lordship.
That's
and
what-
which is stipulated in the advertisement itself. So if we go with the petitioner lawsuit, then we have to violate our own conditions given in the advertisement. One judgment is a lawsuit where it says lawsuit after
Regarding participation,
after
that's,
participation. But
having participated, he cannot turn around
turn back
challenge
turn
the
back and you can
process.
question.
That's all right, but when the advertisement itself is against the law, then what would be the consequence?
This is the exactly lawsuit because if anything is illegal lawsuit. Before entering into the illegality
He
lawsuit.
could have challenged it.
Otherwise, lawsuit, if it's found fit to you, you will remain silent only lawsuit. If you remain silent, doesn't mean that it's legal or it will be illegal only lawsuit. So you have participated in all cases where it has been held that after participation you cannot question lawsuit. There also lawsuit the advertisement itself, there's something wrong is there also in the advertisement. But you have participated. Therefore, Honorable Supreme Court, no, you have participated.
What is the judgment?
Lawsuit, only one judgment. I can't get it. There are lots of judgment on this
No,
issue,
lots of judgment.
but only one judgment of recent lawsuit, 2024 lawsuit. This is Rekha Sharma's case lawsuit. This is selections of judicial officers. Here also the physically handicapped issue lawsuit. If lawsuit, see the paragraph 16 lawsuit. On the last page lawsuit.
Yes.
As well settled, the candidates who consciously took part in the process of selection cannot be permitted to question the advancement or the methodology adopted by the respondent for making selection on their having been declared as unsuccessful in the preliminary examination. The appellants, after they having found that their names do not appear in the list of successful candidates of preliminary examination, could not have questioned the result on the ground that the respondents had not declared the cut-off marks for the person with benchmark disability. As stated earlier, the respondents have declared the cut-off marks for the person falling under compartmentalized horizontal reservation and not for the overall horizontal reservations under which the appellant fall. Under such action could neither be said to be arbitrary nor violative of Article so and so and so. In that view of the matter, we don't find any illegality in the impugned judgment and order passed by the High Court. Both appeals are dismissed accordingly. Here, lawsuit will say you cannot turn around and question the advancement or methodology.
After participation.
Lawsuit. Here, not only the advancement.
This is your only stand.
Yes, I am very limited lawsuit.
Okay.
One way I'm just what is the lawsuit law and other lawsuit what had happened in this case, and this is only my limited submission.
Yes.
In addition to his
Submission.
we have seen the 2018 rules. This is 2018, but advertisement was 2017.
Prior to
Yes.
coming into force of the rule.
Yes.
Acha.
So, from the petition one, election case 50. Dated economic 4 July 2017.
Dated?
4 July 2017. This rule comes in 2018.
There was no retrospective effect. Okay.
That's so far that the application of this rule is concerned. Then also, in fact, in the recruitment rules also provided by the respective departments. These exams were for so many departments. So there also this quota, whatever is there, for PWD was not given. But since there was WPSC came to know about all this, it was advertised. So far, so good. Reservations were kept for them. Now, there is another roster wherein it says that if suppose in the first year, first selection, if quota cannot be filled up, then it will be carried forward for next selection. Then if in the next, in the in second selection, it can be intercepts. If selection is recruitment says that only for PWD, orthopedic, then it can be accessed with blind also. In second round. In third round, if nobody is found eligible, qualified, then it will be covered by general. So that is the procedure. So all this sequence, the practice is it is seen that the practice is ERC reservation is followed, but not in such a way that one applied, if he has qualified for bypass, retail, he will be selected. That is not the case from the practice itself. Now, as per OM, that 7/1/2008, this in fact should have been silenced.
OM page number?
Page number was
Mr. Tagum, it is in the
petition.
petition?
Yes, ma'am.
Page number?
page number 48.
48, ma'am.
48.
This is not challenged. So here the criteria has been given that for one post for selection, 1:3. Ratio is to be taken. Now 60 posts. 60 posts, 60 into 3 is 180. That was taken. Now, if in 180, if within that 180, if somebody from PWD candidates come, then he's selected. That is the procedure we have to follow. So, if within that 180, if PWD do not come, then it goes to general or it's carried forward to next selection process. So that has been done here. In our activity also we have said that one post was there in the selection process that couldn't be filled up. So that has been carried forward in the present selection process.
No, the posts are there.
One post was there.
Only.
One post. Now again, Lordship, apart from that, if there is three more candidates who qualified, total 4 candidates who qualified this criteria, 33 and 45%, along with him. So they are not before us. So in case if interview is taken, then it might so happen that he will be outside. So since they are not parties, we have no say in the matter. But it would have been better if they were made party here. So that is another ground. And there is another annexure in the last page. Yes, annexed that as an example that those who did not qualify 33% and 45% were also call for interview in the another selection process. That provision is also there. If suppose in a given selection process, if number of scheduled track candidates are cannot be fulfilled, suppose 50. If suppose 50 candidates are to be interviewed and the qualified persons are 45. So now in such case, again some relaxation is given to APS candidates. So that provision is also there in the selection process.
After written examination.
Yes, after written examination. That is after written examination. Therefore, the last annexure, which was shown yesterday, it is of that category.
Mr. Apang, how much time you will take?
Let it be 10 minutes.
10 minutes. I have one full court meeting from 1:15 today from HC. So we'll resume at 2 o'clock then.
Right.
Yes.
I was on office memorandum. Now, in this office memorandum, you will not find that there's separate reservation for OBC, ST, and other reserved categories. So this is in general.
Yes.
So now, say for example, ST is 7%, general, so and so. So that is not reflected here. But what is reflected is that how many will be taken for Viva votes. In fact, we are in shortcut. If it is 3-stage examination, then in written there is always a preliminary examination. In preliminary examination, the ratio is taken into 1:12. Now, in this case, there was no preliminary examination. It was straightway mains. Therefore, it comes to 1:3. So now for Viva is 1:3. Then in case if 1:3 is not fulfilled, then we relax. If 1:3 is not fulfilled, we relax it. Relax the cutoff mark and make it 1:3. If it's more than 1:3, then there is no question of I have qualified or I have not qualified. Only on serial. But if any reserved person, PWD person, is under the zone of consideration in that 1:3, then he will be appointed. He will be appointed in the quota. So that is the system. So in this case, one Navam Yate, she qualified. She faced the interview. So despite of having difference of marks, she was appointed in this present case. Whereas there were another 3 candidates who qualified 33% as well as 45%. If we draw the parallel that the petitioner has obtained 45 marks above, then those under 3 is also to be followed. In fact, in written, one lady, she has scored more than him, as per record. But she's not before us because she knows that under 1:3, I am not yet. Because of that, she has not approached it so long. So that is the case in as regards 1:3 Panda. Then also. Yes. one Omom scored 194.75 and petitioner has scored 193.5. So Omom scored more marks than him. But she is not before us and she was not called for interview. So totally, she did not qualify that. Under 1:3 ratio, she did not qualify. And so far, methods and procedure is concerned, this executive rule of business says so. So they have given the main points, but small points, those subsidiary points can be added by the examining authority. So Arunachal Pradesh Public Service Commission is a constitutional body under under the 315 of the Constitution. It has every right of its own. But still we are following the office memorandum for appointment of Arunachal Pradesh officers. Now, in this selection process, there were it's a sort of repetition. Executive for many work departments, not only in one. In this case, 60 posts were there, so 59 appointed. So, if reservation is from the very beginning, so for petition is concerned, if I am right, they want the petitioner the reservation from the very beginning. If that be so, then there has to be a separate examination for them, not in general. Otherwise, if it is in a common approval lawsuit, it will be once selected, there will be a roster of seniority, etc. Then where they will be at? If there is separate examination for that. So that is also a practical thing in future. Now, Lordship, the rule of game has not been challenged. So, comfortably participated. Now, there cannot be about them. So, the citation is already given. At best, Lordship, we could have challenged this OM. If it's an office memorandum, but if it's a gazetted one, again, then there will be a procedural lapse also. If office memorandum is to be challenged, then question of division bench will come again. That also will be there. So, but he is not challenging the office memorandum, but he wants to be inside within this office memorandum. And if this office memorandum is not challenged, then our action that was taken is absolutely right. So that much will be I don't find any merit in that.
Okay. Yes, Mr. Sokia, it is correct.
I am
You are for respondent number
6, 7, 8, 10, and 11, madam.
Yes.
May I please, madam? Basically, my lord, read petitioner is seeking, my lord, employment under the disability quota, my lord, and against the non-selection in the written examination, my lord. My lord, very objective of the, my lord, Disability Act, my lord. May I read the section 34, my lord? My lord, may I read section 34, my lord? Every appropriate government shall appoint in every government establishment not less than 4%, my lord. In state of Arunachal Pradesh, it is 3%, my lord. Of the total number of vacancies in the cadre stand in each group of the post meant to be filled with persons with benchmark disability of which 1% each shall be reserved for persons for benchmark disability under clause A, B, C, for persons with benchmark disability under clause D, E, namely blindness, low vision, hearing, and hearing. These are the categories, my lord. Thereafter, my lord, if on the current, my lord, recruitment year, my lord, if there is no ability and suitable persons to be appointed in the reserve benchmark for, my lord, then it will be carried forward to next, my lord, selection process, my lord. The subsection 2, my lord, of C4, my lord, where in every recruitment year, the vacancy cannot be filled up due to non-availability of the suitable person with the benchmark ability. Suitable manner is manner merit manner. There has to be a manner merit manner.
Yeah.
To adjust the suitability manner, there has to be a process of persons with benchmark disability for any other sufficient reason, such vacancy shall be carried forward in the succeeding recruitment year, manner. My lord, now, my lord, before coming to other aspects, my lord, the petitioner is admittedly, my lord, a Bachelor of Agriculture in Engineering, Bachelor of Agriculture Engineering, my lord. My lord, and my lord, my lord, recruitment rules to this advertised post are, my lord, governed by, my lord, recruitment rule of 2000, my lord, 5, my lord. Whereby the recruitment rule says, my lord, it's a common recruitment rule for all the working engineers, my lord, department, working departments, my lord, for the engineers, my lord, assistant engineers, my lord. The recruitment rules of the, my lord, rules is common, my lord, but there is a note in the recruitment rule that, my lord, persons, my lord, has to be appointed in terms of their requirement of the education qualification, my lord. Says, my lord, PWD, for PWD department, my lord, definitely, my lord, civil engineers are required, my lord. Only exception, my lord, in these categories of the engineering department, my lord, he is, my lord, my lord, Bachelor of Agriculture Engineering, my lord. He will be fit into the, my lord, under the recruitment rules of the, my lord, for the department of the, my lord, WRD, my lord. Whereby, my lord, agricultural engineering is also considered for appointment of the assistant engineer, my lord, along with the civil engineering degrees, my lord. So only identified for his, my lord, category of disability is in WRT department, my lord. My lord, there come, then, my lord, kindly come to the, my lord, advertisement, my lord, in my affidavit also next, my lord. And his, my lord, disability, my lord, is, my lord, orthopedically handicapped, my lord, which was, he has annexed the, my lord, medical certificate also, my lord. Now, my lord, kindly come to, my lord, the advertisement, my lord. Initial advertisement is 11 of my counter affidavit.
Dated 4th of July
4th of July
2017.
2017, my lord.
Yes.
Table, my lord, column, my lord. Total is a common, my lord, examination, my lord, for the reserve category also, and for the non APST, my lord, non-scheduled tribe candidates also, my lord, and including the handicap disability candidates, my lord. PWD, my lord, in tabular form, my lord, reserved for the PWD candidates are shown below, my lord. For this public work department, one post, my lord, low vision, hearing impairment, my lord. He cannot be appointed in PWD, my lord. PWD department, because he is, my lord, orthopedically handicapped, my lord. And, my lord, benchmark identification is for in Department of Public Works Department, low vision and hearing impairment, my lord. And PhD and water supply, my lord. One post, one arm, one leg, locomotor disability, my lord. It's for locomotor disability, my lord, and he is orthopedically handicapped, my lord. And RWD, my lord, blind, visually handicapped, and WRD, my lord, two posts, hearing handicapped and my lord oblique orthopedically handicapped. If he succeeds in the my lord merit my lord, then he can be appointed in WRD only my lord. Again, identify my lord, benchmark my lord. Now, my lord, in the said advertisement, again, my lord, the method of selection has been given, my lord. Page 12, my lord. In the said advertisement, my lord. Serial number 5, my lord. Of serial number 5 of last para, my lord. Number of candidates who shall be called for personal test, viva voce interview will be the ratio of 1:3. That is, candidates for one post as per merit in written examination, subject to securing minimum 33% or more in each written papers and 45% aggregate marks in the aggregate out of total marks in the written examination, my lord. It says, my lord, for to come into the ratio, my lord, of the 1:3, my lord, the my lord, persons has to qualify 40%, 45% mark in aggregate and having passed 33% in all subjects, my lord. Now, for taking consideration, my lord, of the 1:3 ratio, my lord. My lord, the general merits will be counted, my lord. In this instant case, my lord, there are 60 posts, my lord, and my lord, total, my lord, merit list was published pursuant to written examination, my lord. Altogether 198 posts, my lord. 98 persons, my lord. My lord, this, my lord, advertisement was, my lord, slightly at page 14, dated 24/4/2008. There is a post from 48 to 60, my lord. So, my lord, there is also increase in the post reserved for the, my lord, disability candidates, my lord. Now, my lord, this is important, my lord. Rural work departments, total posts, 22 posts, my lord. 18 posts, my lord, are reserved for the APST, my lord, and 4 posts are unreserved, my lord. And, my lord, 1 post for out of which, my lord, 22 posts, 80 is for APST candidate, Arunachal Pradesh Scheduled Tribe, and 4 is general, my lord, and 1 post reserved for PWD candidates, blindness or low vision, my lord. Likewise, my lord, only, my lord, reserved for the petitioner benchmark, my lord, disability, my lord. It is serial number 4, my lord. Water Research Department, my lord. Of 5 numbers, my lord, of which, my lord, 2 posts are reserved for PWD candidates, hearing impairment and orthopedically handicapped, my lord. My lord, according to his benchmark, my lord, if he is, my lord, eligible, my lord, in merit, my lord, he can be, my lord, appointed in the, my lord, WRD department against the benchmark reservation of the orthopedically handicapped, my lord. Now, my lord, kindly, my lord, I will again draw your receipt, my lord, though it is a reputation, my lord, the memorandum of 2008, my lord. Notes you would find at page 19, my lord. My lord, how is the, my lord, the merit has to be determined, my lord. For, my lord, for further selection test, this is, my lord, viva voce test, my lord.
Memorandum dated?
Dated 7/1/2008, my lord. Page 19, my lord, of my counter affidavit, my lord.
In writ petition 48, madam.
It is
48.
also in the
In writ petition 48, madam, page 48. That's it.
48,
Yes,
okay.
same one.
Yes. Mary, madam.
Yes.
Second paragraph, madam. After careful examination of the issues and the modification of the point number 2, 3 of the OM dated 28/8/2006, the government of Arunachal Pradesh has decided to prescribe the following procedure for all direct recruitment examination for appointment to the group A, B, C post under the government of Arunachal Pradesh. For appearing in the viva voce test, candidates shall be selected in the ratio of 1:3. 3 candidates, meaning 3 candidates shall be selected for each vacancy or 3 times of the number of the vacancy on the basis of the written examination manual. The basis of the written examination manual in the advertisement manual, it's a manual, general manual examination manual, calling upon all the categories manual, including the Arunachal Pradesh scheduled tribe, non-APST, and the manual, the reserve categories manual, disability reserve categories. It's an open competition manual, up to the manual selection process manual. However, ratio of 3% shall not apply in case candidates appearing in the written examination is less than 3 times of the number of vacancy. In case of the candidates appearing in the written examination is less than 3%, 3 times of the number of vacancies, all the candidates securing 33% of the mark in each written examination paper shall be eligible for appearing in the viva voce test, my lord. And the meaning there, my lord, suppose, my lord, there are, my lord, less persons, my lord, who has secured less persons, my lord, in terms of the ratio, my lord. Then, my lord, these, my lord, persons who are, my lord, who has obtained, my lord, at least 45% and succeeded in getting 33% shall be called for viva voce test, my lord. The candidate securing a minimum 33% or marks in the each written examination paper and secure 45% marks out of the aggregate total in the written examination paper shall be eligible for viva voce test. On the other hand, it will be further mean the selection of the viva voce test shall be based on the aggregate total secured in the written examination and the subject to the ratio of 1:3, my lord. My lord, there may be candidates who have secured 60% also, my lord. But, my lord, among them, my lord, only, my lord, in the ratio of 1:3 has to be called for viva voce test, my lord. And that will be the, my lord, merit list of the written examination, my lord. And, my lord, now, my lord, kindly come to, my lord, the merit list, my lord. Page 180 of the writ petition, my lord.
Page number
180, my lord.
Only 80. Okay.
80, I think, madam. My lord,
Mr.
page
Thakur, what is
58,
the-
page 58, my lord. Sorry, madam. Page 58 is the result of the written examination, my lord. It's a merit list, my lord. In terms of the ratio laid down in the OM of 2008, my lord. There were 60, my lord, post, my lord, for which, my lord, 180 persons were considered, my lord. And his name does not appear in the list of merit list of 180, my lord. One person, my lord, my lord, has serial number 144 in the same page 59, my lord. 144, roll number 10202. Her name appears at serial number 144. And she was selected, my lord, called for the viva voce, my lord. Because, my lord, the total post is 60, my lord, and by the ratio of the by following the ratio of the 2008, my lord, altogether 180 persons were, my lord, called for viva voce test, my lord. And, my lord, serial number 144 name appears within that 180. So she was called for. She was also a disability candidate, my lord, disabled candidate. She was called for viva voce test, my lord. Now, my lord, the reserve category, my lord, these disabilities are, my lord, are horizontal reservations, my lord, not vertical reservations, my lord. My lord is awarded, my lord. But in vertical reservation, my lord, if, my lord, the ST or SC candidates, my lord, tops the list, my lord, he will not be counted in the, my lord, in the list of
Reserve
the, my lord.
category.
These
He
of
will be in the
reserve
general
category, my lord. My post will be, my lord, can be filled up from the bottom of the merit list also, my lord. But in the vertical, my lord, in the horizontal case, my lord, the objective is that, my lord, out of 100, my lord, posts, my lord, 3 has to be there, my lord. Suppose, my lord, a disabled candidate, my lord, appears in, my lord, his name appears in the merit list of the 3 as 1 or 3, my lord, then it will not be, my lord, on the, my lord, on the unreserved category, my lord. Because, my lord, only necessity and objective is there, my lord. Out of 100, there has to be 3 persons, my lord, in the, my lord, the establishment, my lord. So it is not like, my lord, vertical, my lord. But there has to be, my lord, 3 persons appointed from the merit list of the written examination, my lord. And if it is not, if there is no such person, my lord, suitable person, then it will be, my lord, carry forward in the next subsequent, my lord, examination, my lord. Admittedly, my lord, he does not appear, his name does not appear in the merit list of the 180 persons, my lord. So, my lord, 1 post were kept reserved, my lord. That will be filled up in subsequent, my lord, recruitment process, my lord. So, my lord, in terms of the 2008, my lord, he has to be, my lord, within the, my lord, merit list of the 180, my lord. So, my lord, he is not in the 180, so he was not called for the viva voce test, my lord. And, my lord, secondly, my lord, now, my lord, they have challenged the, my lord, appointment of the respondent number, my lord, 6, 7, 8, 10, 11, my lord, in my case, my lord. My lord, because 6 is, my lord, appointed, my lord, in the department of the PWD, my lord. And in the department of PWD, my lord, his disability is not benchmark for that department, my lord. My lord. And, my lord, and required education qualification is also, my lord, civil engineer for public works department. And, my lord, serial number 6, my lord, he was appointed, my lord, respondent number 6, my lord. Six is, my lord, PWD in the PWD department, and 7, my lord, is, my lord, assistant engineer WRD department, my lord, on his own merit, my lord. And his name appears in the select list, my lord, on the merit list, my lord. After the not merit list, select list, my lord. At serial number. At serial number 12, my lord. And, my lord, respondent number 9 appears at, my lord, serial number 56, and respondent number 10 appears at serial number 57, and respondent number 11 appears at serial number 58 of the select list, my lord.
Respondent number 6 is in serial number?
Respondent number 7, my lord,
7.
is at serial number 12, my lord.
12.
My lord. In WRD department, my lord. On merit, my lord. And, my lord, respondent number 9 is appointed, my lord. Respondent number 9, 10, 11 appointed in the department of RWD, my lord, whose names appear at serial number 56, 57, and 58, my lord. In the RWD department, my lord. And RWD department is the not, my lord, identified, my lord, identified for that reservation, my lord. RWD, my lord, has already seen, my lord. It's for, my lord. RWD is reserved for reserved for, my lord, blindness or low vision, my lord. So he could not have, my lord, if he, when he was in the merit list, my lord, he could not have appointed in that post, my lord, in the department of RWD, my lord. So these are, my lord, the respondents are not necessary parties, my lord. Because, my lord, respondent number 7, my lord, whose name appears as serial number 12, is on its own merit, my lord. He could have been appointed in the WRD department, my lord. And below me also, my lord, there are, my lord, incumbents who were appointed in the WRD department, my lord.
Whether the final selection list is a part of the record?
Yes, yes, my lord. They have, my lord, annexed it, my lord.
Is it
Yes, my lord.
page number?
My lord, page 61 to 63, page 61 of the writ petition, my lord.
In my affidavit also there, my lord.
Okay. Okay. So your stand is that you are not necessary party
Not
in this
necessary.
petition.
Yes, madam.
Your selection is purely on the basis of merit.
Merit, madam.
Okay.
And his, my lord, category of disability is, my lord, orthopedically, my lord. And he can be, if succeeded, my lord, in the merit, my lord, if he is in the merit, my lord, he can be called for viability test. And he, if he succeeds there, my lord, he can be at the best appointed in the WRD department, my lord. Rest, we are not necessary parties, my lord. Further, my lord has to determine, my lord, as to whether the, my lord, merit list prepared by the Public Service Commission is, my lord, correct or incorrect, my lord. Because office memorandum says, my lord, it's a common merit list, my lord, for all categories of the, my lord, reservations, my lord, unreserved and reservations, my lord. And if he has not succeeded, my lord, in the merit list, my lord, within the 180, my lord, and one post is there, still there, my lord, he can compete in the next subsequent, my lord, selection process, my lord. There cannot be separate list for the disabled persons, my lord. Is from the amongst the, my lord, merit list, my lord, which contains 180 persons, my lord. And
that is prior to this 2018 rules.
Rule, man. And my lord, 2018 rule is also clear, my lord. My lord, may I again read the rules, my lord, of 2018, my lord. The rules may not applicable, my lord, retrospectively, my lord, even though, my lord, it is, my lord, it is in the affidavit of the respondent number 12, my lord. At page 10, my lord.
Yes.
Persons with disability selected on their own merit without relaxation along
You are reading?
Page 10, my lord.
Yes.
Of the rule, my lord.
Rule 14.
Rule 11, my lord, eligibility, my lord. 12, my lord.
Rule 11 and let's the expert committee.
No, 12, my lord. 12.
12 eligibility.
12, sub-rule 3, my lord.
Yes.
Persons with a disability selected on their own merit. On their own merit, my lord. Without relaxed standards along with the other candidates, my lord. they have to be, my lord, selected, my lord, in accordance with the OM of the 2008, my lord. On merit, my lord. Then, my lord, reserve candidates shall be filled up separately amongst the eligible candidates who are lower in the merit than the last candidate in the merit list, but otherwise found suitable for appointment if necessary by reserve standard, my lord. Meaning thereby, my lord, he has to come within the, my lord, merit list of the 180, my lord. Then his case can be relaxed for the reserve category, my lord, of the, my lord, disability, my lord. First, my submission is that, my lord, he has to, my lord, come in the merit, my lord, in accordance with the, my lord, office memorandum of the 2008, my lord. Because there are only 60 posts, my lord. 60 posts, my lord. And he does not come within that 60 posts, my lord. Within that 60 posts of the merit, my lord. He even does not come within the 180, my lord. So he was not in the merit, my lord. To qualify for viability test, my lord.
Okay.
So this, my lord, is, my lord, this, my lord, ratio has been laid down in the, my lord, Rajesh Kumar Dharia versus Rajasthan of Public Service Commission, my lord. How to exhaust this, my lord, horizontal, my lord, reservations, my lord. 2007-8 SSC, my lord. Was a paragraph later.
Paragraph number
10, my lord. Here, my lord, though it's regarding the, my lord, reservation of women, my lord. Women, my lord, are also, my lord, horizontal. Their reservation is also comes under horizontal category, my lord. May I read, my lord, 10, my lord. In this case, number of candidates to be selected under general category open competition were 59, out of which 11 were earmarked for the women. When the 59 from the amongst the 261 successful candidates who were taken and then listed as merit, my lord. In our case, my lord, 180, my lord, for 60 posts, my lord. It counted 11 candidates, which was equal to the quota of general category women. There was thus no need for any further selection of the women candidates under the special reservation of women, my lord. And because within, my lord, 59 seats, my lord, there were, my lord, 11, my lord, candidates of women candidates who were, my lord, merit, my lord, in under the merit list, my lord. So, my lord, the horizontal reservation is being completed, my lord. But what PRC did not was not to take only the first 48 candidates in the order of merit, which contain 11 women, and thereafter fill the next 11 posts under the general category with women candidates. As a result, we have been selected consisting of 11 women candidates selected on their own merit at serial number such and such, such and such, such and such of the select list. And another 11 candidates such and such, such and such, such and such, such and such of the select list include under the reservation quota general category women. This is clearly impermissible, madam. And when the, my lord, quota for the, my lord, 11% women is, my lord, being filled up under total post of 59, my lord. Then further, my lord, another, my lord, persons, my lord, who are below the, my lord, the merit list cannot be selected, my lord. Meaning thereby, my lord, there has to be altogether 11 women in the seat for the said post, my lord. This is clearly impermissible. The process of the selection made by PRC can amount to treating the 20% reservation of the women as vertical reservation instead of the horizontal reservation within the vertical reservation. Similarly, we find that in regards to 24 posts for OBC, 19 candidates were selected by RPC in accordance with the merit list from among the OBC candidates, which include 3 women candidates. Thereafter, another 5 women were selected under category of OBC. Instead of adding only 2, which was shortfall, thus there were in all 8 women candidates among 24 OBC candidates. The candidates found in the selection list. The proper course of was to list 24 OBC candidates as per the merit and then find out the number of candidates among them and only fill the shortfall, make up the quota for the 5 or 4 women matter. I am submitting because my lord, suppose my lord, C comes within the select, my lord, the merit list of 180 list, my lord, and her name appears within the 180. From 62 my lord 180, then her case can be considered amongst the my lord reserved categories, my lord, for the appointment within the reserved category of the my lord disability, my lord. My submission is there, my lord. And
Okay. Yes, Mr. Tagum, any reply?
Yes, my lord. You will say? Okay, one more is there, my lord, response.
That's it. You are for?
Respondent number 8.
8.
Yes. My lord, while adding to the submission already made, my brief submission where, my lord, this situation that I'm placed in is not my own doing. It has nothing to do with anything I have done. If my lord will peruse the listed page number 61, in merit, I am serial number 15. I am an agricultural engineering student, candidate who was qualified, who was selected.
Serial number 55. 15.
15.
Okay.
So, my lord, I was recommended to the WRD department, and accordingly, I was appointed. Now, if my lord will see the rest of the list, there are other agricultural engineering candidates who have been appointed to RWD department, who are belonging in the merit list. Now, my selection.
So you are on merit.
I'm on merit.
Okay.
On merit, I am.
So you are not a necessary party to this proceeding.
My lord, my.
That is your contention.
Yes.
Okay. All right. All right.
My lord, just I'll give a brief, short reply, my lord. The first thing, my lord, the judgment relied by Lana Senior Government Advocate, my lord, Senior Counsel Government Advocate, Senior Government Advocate, my lord, regarding that once participated, you cannot challenge, my lord. That is not absolute as in such cases, my lord. It is when they were, my lord, in my case, I'm not challenging the recruitment, my lord. Illegality committed by the authority, I'm challenging, my lord. In that case, it is not absolute, even in the most, in all, any of the case, my lord, pick up, my lord, relating this such nature matter. When there is a illegality, arbitrariness, and violation of statutory rules, my lord, it's always subject to challenge, my lord, judicial. It's always that in every case, my lord. So therefore, it's not applicable in my case. Now, my lord, the further, my lord, one Daria case, my lord. Daria case, my lord, it is rather in my favor, my lord. It says that, my lord, among these, my lord, 5 reserve quota, among them only 1 has been selected, my lord. What about the 4 of them, my lord? That has not been done. That is against the ratio laid down by the Daria case, my lord. They are to be seen. And if it's not there, the bottom one has to be deleted, and there has to be those PW category has to be taken into the list, my lord. That has not been done. Now, my lord. Now, with regard to the specific violation of the PWD Act 2016, my lord, for the time being, my lord, although it has been repeatedly referred to, but section 34(2), my lord. Section 34, subsection 2. Just, my lord, for reference, section 34, subsection 2, my lord. Well, I'll just only explain this section, subsection 2. What it says is, in every recruitment year, the vacancy not filled up by the due to non-availability to suitable person with benchmark disability for or other reason, vacancy has to be carried forward in the succeeding recruitment year. If in the succeeding recruitment year also suitable person benchmark is not available,
Then in third stage, my lord, it may first filled by interchange among 5 categories, my lord. First time, it's not available, it's to be carried for succeeding recruitment year. In the succeeding recruitment year also, it's not available. Then in third time, my lord, then it should be interchange among those categories, my lord, reserve categories, PWD, whosoever they are under qualified, my lord. Now, if at the third stage, if nobody is there, then they may fill up from the general pool, my lord. That is what subsection 2 of section 34 says, my lord. Now, my lord will see again, it is for reference, my lord. Advertisement, my lord will see at page 50, once again, my lord, for in reference to this section particularly, this section 1, page 50 of my writ petition, for the time being, my lord. My lord, in subsection 2 of section 34, first succeeding, if first recruitment year, if it's not there, then second year, it will be forwarded. If the second year it's not available, then a third year, my lord, there should be interchange, my lord. If this, then, if not then it can be filled up. Now, my lord, will see at details of post reserved for PWD candidate shown below, my lord. Now, see, the first PWD 1 post, my lord, is how many? 2 times, my lord. Number of recruitment examination, including present, 2 times. Now, this has to be carried forward to the next, my lord. Third time, if it's not there, then the interchange. Now, PHE, my lord, 1. Third times. Now, in this third times, my lord, this post has been filled up by the one of the PWD candidate, my lord. Third time. Now, my lord, RWD 1. This is the first time, my lord, RW 1. Now, WRD, my lord, 2 times. Now, this has to be forwarded, my lord. Third, my lord, in the third time, my lord, if there's nobody, then interchange, my lord. Now, my lord, advertisement. It is clear cut, my lord. In the next page 51, my lord, the ratio is there, my lord. Now, it is reference to page 48, OM 2008. OM 2008 says what? It says 1:3 shall be called against each vacancy, my lord. Now, this vacancy 5, it is a vacancy mean for PWD, my lord. It's not for general, my lord. It is PWD specific, my lord. Therefore, this 5 is for vacancy. Against this 5 vacancy, my lord, 1:3 has to be called for. This vacancy cannot be constituted as a vacancy of the general category. Categorically, it is in their advertisement itself. The 5% vacancy, which is related to the OM 2008 says against each vacancy. Each vacancy is a vacancy for the PWD, my lord. Now, my lord, this out of 5 posts, my lord, 1 PW already selected, my lord, as I said, my lord. Now, only remaining, my lord, that is from PWD candidate, my lord. That is PHE, my lord. PHE, my lord, her selection at page 63, my lord. I've mentioned in my writ petition, my lord, page 63. Page 63, serial number 59, my lord. She's the only Nabum Yatte, PHE against PWD quota, my lord. Page 63 of my writ petition, my lord. Now she has been appointed. That is against the third times, my lord. On third time, she has been appointed. Now, my lord, you see, now remaining reserve post of PWD is 4, my lord. Only 4. Out of which 1 post under RWD has been kept vacant, my lord. The 3 posts has been illegally filled up by the general candidate in utter violation of subsection 2 of section 34, my lord. 3 posts, my lord. My lord will see, they say that there's no reservation policy. We do not apply reservation policy. Now, my lord will take the addendum dated 24 July 2019, issued by APCSC, my lord, where 1 post under RWD has been kept vacant, referring OM dated 21 June 2012, my lord, at page 64, my lord. It is just their stand is contrary to what they have done, my lord. Page 64, my lord. My lord, see, this is the addendum, keeping vacant 1 RWD, the vacant post. My lord, second last line, my lord. Accordingly, post has been kept vacant to be filled up in subsequent recruitment year in terms of government notification OM number dated 21 June 2012, my lord. Now this OM number, my lord, you see at page 65. In terms of one way, they are saying that no reservation done. Now in their record itself that reservation has been done, but they have utterly they have violated. Now, my lord, see, page 64 is OM dated 21 June 2024. Reservation for PWD in A, B, my lord. The paragraph second, my lord, that is to compulsory, my lord, there should be reservation. And the import language of section 34(2) has been reproduced, my lord, quoted. Third, fourth paragraph now. Now, my lord, last paragraph, my lord, see. Any other terms and conditions which are not specified herein shall be governed by the relevant act and rules guidelines issued by government. Notice there now. Now, my lord, next question is, my lord, reservation of PWD candidate, my lord. My humble submission, my lord, reservation of PWD candidate, it starts right from written examination itself, my lord. Once they secure the qualifying cut-off marks, my lord, they should be enlisted for viva voice at the ratio of 1:3 against 5 posts reserved for PWD candidate, my lord. They have not done, my lord. Why I'm saying this, my lord? This will be further fortified by the provision statute itself, my lord. My lord, I'm saying this because, my lord, for the time being, to substantiate this my stain, my lord, to see PWD rules 2017, my lord, in the BR Act, my lord, or not, Person with Disability Act 2016.
The central rules.
Yes, central rules, my lord. Is equally applicable, my lord. My lord, Rule 11, my lord. Rule 11, how the computation of the vacancy has to be done. Rule 11, my lord. It has to be done in totality, my lord, in total sanction strength. Now, my lord, for relevant purpose, only sub-rule 3, my lord. While making advertisement to fill up vacancy, every government establishment shall indicate number of vacancy reserved for each class of person with disability in accordance with provision section 34, which they have done in their advertisement itself, my lord. Page 50 of my writ petition, my lord. They have done it, but they have not followed it, my lord. They have flouted their own, the condition, game of rule they have set for that has been flouted by the commissioner itself. Now, sub-rule 4, my lord. Reservation of person with disability in accordance with the provision of section 30 shall be horizontal, and a vacancy for a person with disability shall be maintained as a separate class, man. That's once. What is requirement is that the PWD candidate should reach the qualified cut-off mark. Man. Once he get a cut-off mark, cross the cut-off mark, then that's to be treated as a separate class, and they should be maintained as a separate class and list, my lord. And finally, my lord, if the final list, my lord, if they are not on the in the top, my lord, then those who qualified, my lord, have to be taken into the list, and all those general category within the vertical reservation, my lord, from down they have to be deleted and they have to be brought in, my lord. My lord, basic, my lord, apart from the how this computation and how this calculation and adjustment has to be done, madam. Basic difference between this vertical and horizontal is, in case of vertical, my lord, the person who does secure the highest mark, he may not calculate, his post may not be calculated under vertical reserve post, my lord. He may be adjusted in the general quota, but in the vertical, my lord, in the horizontal model, this is the reservation is there, but the sanction strength should be, all posts should be within the limited vertical model, among them only to see that how many PWD candidates is there. If the reserve PWD numbers of reserve quota is not there, then qualified, having qualified the cut-off mark that has to be seen, Malo. If it's not there, then that is brought in the list, Malo. And the bottom of the general, that is to be deleted, my lord. This is what, my lord, is all about. Now, regarding, my lord, Arunachal Pradesh right of public person with disability rules 2018, my lord. Now, there also, it is clear, my lord, language is clear, my lord. My lord, this rule, the examination, written examination was conducted, my lord, on 12 February 2019. And this act, by then this act is already enforced, my lord. It was formally notified in the November, and thereafter a gazette publication was on 8 December 2018.
Advertisement in the year 2017.
My lord, that is there, my lord. So for written examination part, my lord. That is why.
There is then.
Now that even for a reference, my lord, how I say that the intention of the legislature, my lord, it's always start from the beginning, from the written examination. For a time being, my lord, just may refer the affidavit filed by R12, my lord. I'm summing up only, my lord. Respondent 12, my lord. Page 9. Page 9, rule 12, my lord.
Yes.
Rule 12, my lord. Eligibility for appointment of person with disabilities, my lord. Notwithstanding contained in any rules or order for a time being enforced relating to the recruitment and condition of the service, person appointed to the various services posts in connection with the affairs of any establishment, every establishment, including the government establishment. Person with the benchmark shall be eligible for appointment to the post identified under Rule 14 of these rules, provided fulfill the qualification laid down in the recruitment rule of serviceman. I qualified, my lord. Recruitment rule 2, it is governed by recruitment rule 2005, my lord. I'm within this recruitment rule. I'm eligible. I qualified and succeeded in even advertisement also, securing cut-off marks, my lord, crossing even cut-off marks, my lord. Now, 2, my lord. In posts which are identified suitable for a person with disability, a person with disability cannot be denied the right to compete for appointment against unreserved vacancy, provided such post is identified suitable for a person with disability of the relevant categories. 3, my lord. Next page, my lord. 10. Person with disability selected on their own merit without relaxed standard along with the other candidate will not be adjusted against a reserved share of vacancy. That anybody who was from the even reserved category, if succeed, other, my lord, that 5 posts will not be shared, my lord. It will be remain intact, my lord. The reserved vacancy shall be filled up separately from amongst eligible candidates who are lower in merit, not last, my lord, but otherwise suitable, my lord. Once I'm qualified in cut-off marks, I'm suitable, my lord. Now, my lord, again, my lord, this rule 14, sub-rule 2, my lord, post identify its disability under so and so shall be horizontal and shall be maintained as a separate class. Now, my lord, importantly, my lord, why I'm saying that this start from beginning, my lord. Rule 18, my lord, at page 12 will clarify, further clarify, my lord. My lord, if it is not, my lord, language, my lord, see rule 18, my lord, at page 12. The following concession shall be allowed to the person with which the benchmark disability to make them eligible for appointment under Rule 14. 5% of qualifying pass mark in individual mark is talk about written examination, madam, and aggregates marks wherever prescribed. Now, when this is clear, clear cut in the read, it start from written examination. If it's not qualified, if it do not cross the cut-off marks, then 5% concession has to be given in order to make them eligible for appointment and for further, my lord, for interview, my lord. This is, my lord. In my case, man, I qualified beyond more than that of the cut-off mark prescribed under in the advertisement itself. Therefore, my respectful submission, my lord, in my respectful submission, my lord, it is because of the fault committed by the authority. I have been victimized, my lord. My lord, at the beginning, I have already said, my lord, the posts in the darkest hour of the state of Arunachal, the posts were being sold in the market, my lord. Many officers were arrested, the connection to the PSC, and commission was dissolved, my lord. Now, after, my lord, that's been dissolved. Because of this, my lord.
Be the ground here.
My lord, that is why, my lord, respect, my lord, the great injustice has been done, my lord. To the such.
Heard Mr. T. Tagam, learned counsel for the petitioner, and Mr. A. Apang, learned senior counsel assisted by Mr. K. Lawyer, learned counsel for the respondent number. You are for respondent.
One, my lord, respondent one.
One. And Mr. Soikia or Soikia for respondent number 6, 7, 8.
7, 9, not 8, 6, 7, 9, 10, 11.
6, 7, 9, 10, and 11. And Mr. Talo for respondent number 8. Respondent number 8. Argument concluded, judgment reserved.
Deeply obliged, my lord.
Selecting are very good.
Sama. This it is very good. Print out the level.
Marvelous, my lord. My lord, I'll take the lordship to the additional document. As this one, lordship is short for the order in the CRP number 54. I will take the lordship to the page number 23. Despite of going into the entire, my lord, on 23, my lord. My lord, God. Page number 23 in the additional document, my lord. This is the order in CRP number 54, which was passed on 6/6/24, my lord. And conclusion on 24, my lord. In view of the above discussion hearing, my considered opinion, no ground has been made out to the learned counsel for the petitioner to interpret the impugn order number 6 passed by the additional deputy commissioner Nari, Lower Siang districts. Accordingly, the revision is dismissed. The additional deputy commissioner Nari, Siang district is directed to ensure no one should erect the structure, either gate or the wall, which would obstruct the pathway of the people at the Nari place. Now, my lord, in continuation to this, I will take the lordship to the page number, my lord, in annexure A. I complied this order of this honorable court in the page number 10, whereby, my lord, I have made the intimation to the additional deputy commissioner Nari, intimating that I have complied the court order whereby I have demolished the gate in dispute. My lord, page 10. This intimation has been made, my lord.
You obtained instruction from the ADC.
I have called up, I have taken telephonically the instruction, Lordship. Please say that the iron gate was, of course, Lordship, removed, but then in that place, she have again put up the bamboo barricade, Lordship. That has been removed by the
Authority, my lord. And I accept that, my lord. I have no dispute over that. Now the question is, my lord, in the name of when the official staff has visited to remove the bamboo gate, my lord. After left the, my lord, after the left of this official staff, all the iron post which was beyond the disputed area has been rooted up, my lord. So my lord will find in the page number 13, annexure D. This is beyond the, my lord, disputed area. And I came to know that because that inspection was done in my absence when I was at the Itanagar. So my lord, this is undisputed portion has been, my lord, erected. So my complaint before the authority was that in the name of the staff, the damage has been met by removing the iron post. Therefore, this representation, this complaint has been submitted before the, my lord, respondent number 2, which is, my lord, respondent number 1 and 2, my lord,
It's the same.
sub-divisional officer and the ADC is the same person, man. Just to take the action against that, who is the person involving in the removing this, my lord, iron pillar beyond this disputed area. So, my lord,
Lordship,
my
regarding
problem
this
is,
also
my
I have
lord,
taken instruction, this
lies with
showing
you.
the photograph. And then if your lordship see the photograph, this was then narrowing the place, the pathway. Only person can walk towards it. No car can go through. But then this was being uprooted by the private person in the CRP, not by the authority. So, and then here in this, the private respondent, there is not the party in this writ petition WPC. The person who has removed, he is not the party here. And then this place is, the photograph which is shown here, this belongs to that respondent.
No, my
Who
lord,
was
this is
in
the
the-
wrong
who was in
submission.
the-
The photo is, my lord, belong to me. What has been shown erected. That is why, my lord, complaint has been
What
made.
I have been told is that it was narrowing, the pathway was narrowing with this post. So it has been uprooted by the private respondent.
Therefore, my lord.
Private respondent.
No.
Yes, not by the authority. And
So
then
the
this
dispute
private-
is between two private persons.
Yes, Lordship.
Dispute is
So
between
then-
two private
then,
persons.
whether this writ petition is maintainable.
No, my lord.
Can in
All-
lead jurisdiction,
all-
we can resolve the private disputes between
My lord-
private parties.
No, man. Only the question is that my representation, my complaint has not been attended by the additional deputy commissioner because the problem is lies there. That is why, my lord, I am categorically stated also, I have not made the other person as a, my lord,
When
private
you
respondent.
submitted your representation.
My lord, on page number 15, my lord, tab out copy. Here, my lord,
So then we dispose of this petition directing him to dispose your representation dated 13/11.
exactly, my lord. That is my prayer, my lord. Before this honorable court, my lord. That is my prayer.
Heard Mr. C. Mode, learned counsel for the petitioner, and also heard me, Madam Ite, learned additional government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has rightful issuing direction to the respondent authorities. It will get additional deputy commissioner come, subdivisional officer Nari, to dispose of the complaints representation submitted by the petitioner on 13/11/2024. Directing the authorities to pass a speaking order in the pair being made in the aforesaid representation. Mr. Modi, learned counsel for the petitioner, submits that person to order of this court dated 6/6/2024 passed in WPC number.
CRP number
CRP.
54.
Passed in CRP number. No. Yes, what is the number?
54, my lord. 54. CRP number 54, 2023.
Passed in CRP number 54 of 2023. He had dismantled the gate. And thereafter, he had carried out the said order. And the ADC also visited the site and also confirmed compliance of the High Court order. And taking advantage of the spot visit of the staff and during absence of the petitioner, one Zumbam Koyo, one Srimati Zumbam Koyo has removed the iron fencing post illegally in the name of the staff. Then in connection with the said action of Srimati Zumbam Koyo, the petitioner has lodged one complaint with the ADC come SDO Nari on 13/11/2024 to initiate legal action. But the same has not yet been attended to by the ADC come SDO Nari. Mr. Modi Learned Counsel for the petitioner submits that this writ petition can be disposed of by directing the SDO, by directing the ADC come SDO Nari, the respondent number 1 and 2 herein to dispose of the representation dated 13/11/2023 filed by the petitioner. My senior learned government advocate also agreed to the submission so advanced by Mr. Modi Learned Counsel for the petitioner. We are taking note of the submission of learned advocates about the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this writ petition by directing the respondent authorities to dispose of the representation filed by the petitioner on 13/11/2024 by passing a region order in terms of this WPC instance.
Preferably within 1 month.
Okay, preferably within a period of 1 month from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent authorities within a period of 1 week from today.
All right.
Next.
The issue in this case is very small. The petitioner got a work order for supply of certain materials. Very small issue. The petitioner got a work order for supply of materials in connection with an NREGA. And the time for completion for supply of materials was 6 months. But someone challenged the order, then there was a stay for more than 1 month. Then there was a breach call. 2-3 reasons where the general election was there, for which we couldn't complete. And basically, the position is such that we want another 15 days, maybe 20, at best, and 1 month to complete. Now, instead of giving us extension, the government has floated a fresh tender. Now, similar nature of work in other districts, my lord, when the contractors could not complete their work, extension was granted. And in our case, my lord, I have been writing to the project director, who is the authority to recommend. He has not taken any call, and there is a political pressure on him, my lord. Now, the government has filed an affidavit saying that since there is no recommendation from the project director, we could not do anything. My lord, may I kindly have a look at this? This will be page 91, my lord. Just one paragraph will clinch the issue, my lord.
91.
91. And the
No, there is only 65 pages in the writ petition.
No, but the affidavit, I'm talking about the affidavit.
Sharma, where is the affidavit?
Affidavit filed by December 1, 2, and 3. State respondents. The affidavit filed by the state respondents, my lord.
Yes.
Lordship may kindly see
Page number?
page 91, my lord.
Yes.
Para 8 at the bottom.
Hmm.
That with regard to statements made in para 7, 8, 9, and 10 of the additional affidavit to the writ petition, the deponent begs to state that there cannot be automatic extension of time for execution of the work. The formal procedure is that the project director of the concerned district has to recommend for extension of the time period for execution of the work before Directorate Office Headquarters, Itanagar. On receiving such recommendation, the director or the rural development, after giving due consideration to the request, gives approval for extension of time. For instance, in the case of Kradadi district and Longding district, the project directors of concerned district had on 28/5/2024 and 1/8/2024 recommended for extension of time for execution of the work. Attending the recommendation of the project director, the director of rural development has approved extension of time for Kradadi district on so and for Longding district on so. Apparently, in the case of the petitioner, the department has not received any recommendation from the project director, Kurumkume district, for extension of time for execution of work. It is due to this reason the authorities have issued a fresh NIT for Kurumkume district for the financial year 2024. This is the issue, madam. And the agreement which was executed after the work order was awarded, my lord, Lordship will find there is a provision for extension, and in exercise of this rule, my lord, this term in the agreement, the authorities have extended in respect of others. But so far as I am concerned, page 29
Of the writ petition.
of the writ petition. But page 36, I'm sorry, man, page 36. Page 36, my lord, under serial number 2A, that the second party shall and will execute the work covered by the items mentioned in the schedule annexed to this agreement at the rates and as per the terms and conditions of this agreement, whatsoever called upon to do so by the engineer in charge within a period of 6 months from the date thereof. So I have to complete supplies within 6 months. Now, clause D, Lordship may kindly see that the second party shall start execution of terms of contract mentioned in the schedule annexed to this agreement within 15 days from 31st of January 2024 on receipt of letter to the effect from the engineer in charge or from any date fixed in the said letter, and shall complete the said work within the time fixed by the engineer in charge or as extended by him from time to time. I am only praying for an extension of few days, my lord. This I have taken a specific plea in the writ petition that this extension in respect of other districts for the similar work was granted to all, and it is in response to that they have said that we have granted extension because there was a recommendation by the project director, but in your case till now we have not received any recommendation from the project director. Number one. And number two, my lord, in other districts they have paid normal extension. In my case, I have not paid for an extension in a normal circumstances. It is because number one, my lord, there was a bridge collapse. Number two, there was a writ petition for which there was a stay order of this work, and I could not complete use of my complete 6 months time.
So
and
number one, there was a bridge collapse.
My lord, and these are all admitted fact, my lord. And number two, there was a stay order, my lord, from 5/2/24 to 13/3/2024, more than a month.
5/2/2024
to 13th of March 2024. There was a stay order in connection with the writ petition of this work.
In WPC number?
In WPC number, I am giving. Stay order. WPC 56 of 2024, my lord. 50. I'm sorry, 50, my lord. 50 AP of 2024, which your lordship will find at page 42. These are all admitted positions, my lord.
Any other ground?
And then thirdly, my lord, there was because of the model code of conduct, my lord,
Election.
General election. And these facts they have in the affidavit in opposition, they have said we are not commenting anything. And if the authorities are actually
Because of this general election?
general election, when was the election?
And assembly election.
Yes, ma'am. After the stay orders were vacated, model code of conduct came into operation, ma'am. And that is why I paid for extension by filing representation from time to time. Recently, when they filed this affidavit taking this stand, we have filed a rejoinder saying that there is a, I could not name actually, there are authorities in the local politics, they are pressurizing the project director not to grant extension. And now they have floated fresh tender. Interestingly, my lord, in the fresh tender, the persons who will, my lord, ultimately participate are all those persons who are already having this work order and praying for extension. And they have filed separate writ petitions. I'm not there, my lord. Separate writ petitions will be filed. That is why there are quite a few writ petitions. These persons will again participate in the new fresh tender process. So they want an extension instead of participating in the new tender. If the authorities are actually interested in procuring the materials in terms of the NIT, then instead of again undertaking a process of a tender, they can give us an extension. We are saying that we give us an extension for at least 15 days or at 1 month, we'll complete the supplies.
Now you are paying for extension.
Only money.
How many days?
I am praying for 1 month. If your lordship grants 15 days also, my land prince, they will be able to complete. And I am praying on absolutely on a genuine ground, my lord. In other districts, my lord, they have prayed for extension was granted. There was no stay order in those cases. And these are all admitted positions, my lord. 6 months time, my lord, if in these, because of breach corrupt, because of model code of conduct, because of stay order, more than 2 months have been consumed.
So total period was 6 months.
6 months, my lord.
And out of these 6 months, 2 months because of this breach collapse, stay order,
my lord, and this
model code of conduct.
My lord. And I filed a representation citing all these grounds, and the representation has not been addressed to till date.
Yet to be disposed of.
Yes. And my representation was submitted, my lord, on 9/7/2024, 30th/7/2024, then 18th of September 2024. Instead of disposing of those representations, they have come up with a fresh NIT on
9/7/2024.
My lord, page 57. 30th July 2024, page 58. 18th September 2024, page 60. Without disposing of those representations, they have come out with a fresh NIT on 29/10/2024, which is available at page 64.
29/10/2024.
Which is available at page 64.
It is state by now?
Yes, madam. Interim order. Interim state. When was the order passed?
Yes, Mr. Pisa.
Well, Picha is very generous.
Generous.
Yes, he's very
Jealous or generous?
Generous.
Generous.
His look itself says, my lord.
But I will not be generous.
I'm not paying for any fresh work order, but I'm only paying for extension so that I can complete the work and nothing else.
Mr. Pisa, grant 15 days time then, extend it.
Because tender process itself will take another 6 months. So they will be losing rather.
15 days, my lord, we are processing with the new tenders. Old tender has for the black. It was for the year, for the financial year 2023-24. May I? They are seeking time for extension of and for execution of their work. Whether firstly for that they can file a repetition on whether the rate is maintainable. They should have approached the civil court if there is a contract between the state authorities and the petitioner. Now,
no, that's all right. Without going into the nitty-gritties of the case, you extend it for 15 days.
But can it be possible for 10 minutes, sir. So that
10
I can
minutes.
instruction. Yes.
All right, you obtain instruction, all right,
Let him take. Better.
after 10 minutes.
My lord.
My lord, there is an urgency in this matter. It's a tender matter, and there is a stay order operated. So if possible, I'm requesting my learned senior to argue the matter, and if possible, it can be disposed, my lord, today.
Today,
Yes, my lord.
Well, here also issue is not a very big issue, although it's a tender matter. Issue is like this manner. There were two tenderers, including the petitioner. Now, in the technical bit, both of us were found responsive. In the financial bit, my lord, Lordship may straightway go to the impugned document that will clinch the clarify the whole thing. Lordship may kindly go to page 168.
168.
The tender was for
In the writ petition,
my lord,
168.
168.
No, there is no 168 page number.
Affidavit in
My lord is I'm saying about a running page, my lord. Because the affidavit starts from page 142.
Affidavit.
Yes, my lord. It starts from page 142 and running page 168 is the relevant paragraph where they have given the minutes of the meeting of the financial bit, my lord. Just 3 lines, my lord. Start from page 168, my lord.
Yes.
On top, Lord will find financial scrutiny. Infrastructure development of government secondary school at Kamba. Technical bid submitted by the bidders, namely so that is TJ Enterprises is the writ petitioner, my lord, and Messrs. T. Gangkak is the respondent here. Enterprises were scrutinized, accepted, and conveyed by letter number so. Time and date of opening of financial bid were fixed on so. Financial bids of the qualified bidders were opened on at and under the chairmanship of the surveyor of work 2 and the other members. The committee for scrutiny and evaluation of tender was constituted on The committee has evaluated the financial bids submitted by qualified bidders and tabulated the summary as below. Now, Lord will find the last 2 columns are one for the TG Enterprises, the writ petitioner, and the last one is for the private respondent, my lord. The third from the end, my lord, there is approved NIT. Approved NIT is 10 crore 47 lakhs. The writ petitioner has quoted 9 crore. The respondent has quoted 9.87 crore. Now the item-wise rate has been given in the table below. I'll come to this a little later, my lord. Lord, may kindly turn to next page, my lord. That is the finding. Just 3 lines. From the above, it is revealed that the rates adopted by Messrs. TJ Enterprises is not justified and not acceptable. That is the writ petitioner's, my lord. The other firm, Messrs. T. Gangkak Enterprises, is also not acceptable due to CBC guidelines. So far as CBC guidelines is concerned, since the private respondent could not somehow meet the requirements, so their tender has been rejected on the ground that they did not meet the requirement of CBC guidelines, and they have not challenged this. They have not challenged this by filing any writ petition. Petitioner has challenged this on the ground that rejection of his bid on the ground that it is not justified and not accepted is not, my lord, in pursuance of the terms of the agreement. Now, in the affidavit, they have tried to improve it, and our contention is this, my lord, the authorities are actually trying to ensure that the work is executed by private respondent whose bid has been rejected on the ground of non-compliance with CBC guidelines. That is our allegation. And so far as petitioner is concerned, my lord, in the affidavit they have filed, they are saying that the rate you have quoted is too low.
No, in the minutes of the meeting, they have not stated anything about.
No, that is my submission. First thing is, there is no reason recorded. By filing an affidavit, they are trying to justify it. And my submission before your lordship are twofold. Number one, so far as the minutes of the meeting is concerned, they are saying it is not justified and not acceptable. It is absolutely vague. And my submission before lordship is that it is arbitrary.
So, what they have stated in the affidavit?
Affidavit, they page 145, minute. Para 9.
Yes.
That with regard to the statement made in para 12 of the petition, the answering respondent begs to state that petitioner has quoted 14% below the tendered amount, and major items like internal electrification and carrying items has been drastically varied from the approved cost and specification. My lord, my submissions are twofold as I submitted, my lord. These ground
Yes.
My lord, my submission before lordship is, my lord, that first of all, in the minutes of the meeting, there is no clarity as to on what ground they are rejecting it. They are simply saying it is not justified and not acceptable.
No, the legal position is that
My lord.
if it is not there, by subsequent filing of this affidavit, you cannot improve it.
Absolutely, your lordship is referring to Gordon Das and the Mohinder Singh Gill. I have brought the 1952 Supreme Court which your lordship is referring.
Yes, another judgment I have seen.
Mohinder Singh, it has been referred in subsequent judgment also. First
Gill.
Mohinder
Yes,
Singh
yes,
Gill.
yes.
Well, I have brought these two judgments.
Okay.
That is my submission, my lord.
Okay.
It has fallen from your lordship's mouth. I am very grateful to your lordship, my lord. That if it is not there in your document, it's a public document, publicly issued, it has to be justified by what is mentioned therein. By filing an affidavit, subsequently you cannot improve it. That is my first submission. Second is, my lord, these grounds on which they are now saying has not been taken by the authority in the minutes of the meeting.
Yes. Mohinder Singh Gill.
Yes, Mohinder Singh Gill, my lord, 78 Supreme Court. Well, I have brought the judgment. I am grateful to your lordship. Well, what I am saying is, my lord, and now lordship may kindly turn to the table. Why, even assuming that they can take some ground as mentioned in para 9, page 168. What they are saying in page 145 is that major items like internal electrification and there is a variation. First of all, 40%, there is no, my lord, your lordship is aware if they want to fix any variation, any, my lord, what is called this justification. Now there is a concept of justification. This justification is not there in the tender documents number one. And number two, this 14% variation, if it is not permissible, this has to be clearly mentioned in the tender document. It is not mentioned. And that is why I am relying on that judgment of my lord that Now, my lord, lordship may kindly say what the ground they have taken. Because ultimately what they are saying is 14% below the tendered amount. Now, lordship may kindly see page 168 where there is a variation. What kind of variation is there, my lord? Page 168 in the table. In the table, my lord.
168.
168. There they have given the my lord, evaluation. Approved NIT, one column is there, my lord. Now, serial number 1.1, external electrical service connection. Rate, according to the approved NIT, 32,44,000. And we have quoted 40 lakhs. What we have seen. It is 23.5% above, not below. They are saying they have taken the plea that you have quoted a rate which is 14% below the tendered amount. So here it is above. Next is additional carriage charges. Government approved rate is 1,12,96,000. And the rate we have quoted is 90, that is 3,12 lakhs. Yeah? 3,12,277, which is 97.24% below. One is above, one is below. Then third one is wearing. Wearing is 48.79% above. So the authority should be concerned with the quality of wearing, and quality wearing I am on the higher side. That is what I am trying to say, my lord. 1.1 external electrical service connection is 23.5% above the government rate. And then third one is wearing, that is 48.79% above. Only the 1.4 distribution boards is 81% below. And then 1.5, there is supply of light fixtures and fans, that is 60% below. And then next one is fire detection and alarm system, that is 56.72% below. Amongst the important items, my lord. Now they have, and these, my lord, they have taken the plea that it is not justified and not acceptable simply. So my submission before lordship is, my lord, they are trying to improve it by filing an affidavit saying that it is 14% below your tendered amount, whereas it somewhere it is above, somewhere it is below. So they could not justify it even by this plea they have taken in para 9. And so far as ultimate finding of the committee in the financial bid is concerned, they are simply saying that it's not justified and not acceptable. Well, I'm relying on these two judgments. One is, my lord, Datta Associates, your lordship is aware of that, my lord. That is the only ground here. And they have not given any opportunity of hearing before actually. Para 4, my lord, only one paragraph. After hearing the parties, we are of the opinion that entire process leading to the acceptance of the appellant's tender is vitiated by more than one illegality. Firstly, the tender notice did not specify the viability range, nor did it say that only the tenders coming within the viability range will be considered. More significantly, the tender notice did not even say that after receiving the tenders, the commissioner government would first determine the viability range and would then call upon the lowest eligible tenderer to make a counter offer. The exercise of determining the viability range and calling upon Datta Associates to make a counter offer on the alleged ground that he was the lowest tenderer among the eligible tenderers is outside the tendered notice. Fairness demanded that authority should have notified in the tender notice itself the procedure which they proposed to adopt while accepting the tender. They did nothing of that sort. Secondly, we have not been able to understand the very concept of viability range through those three so Land Council for the appellant and the Land Council for the state of Assam tried to explain it to us. The Land Council stated that because of the control of molasses, we need not go into all these things. These are in the facts of that case. And the secondly, my lord, there is another judgment of our High Court. Single bench item. That is 2023, 12 copy books. Yes, yes. Here, madam, para 27 onwards, which your lordship was just saying, madam. Starting from para 27, there is no dispute to the fact that owner which floats a notice inviting tender has a discretion to accept a bid which may not be highest or lowest, depending upon whether it is a revenue fetching contract or a construction or supply contract. The rules itself prescribe that the bid of the highest lowest bidder is generally to be accepted unless there are compelling reasons not to do so. In the instant case, as per the records, the appropriate authority had come to the finding that the bids of the petitioner were on the higher side and the settlement made with excessive high rate can cause undue harassment to the consumers. The aforesaid reason, however, needs to be tested with the clauses of the tender itself. Then para 29, when the rates are predetermined in a part of the tender document accepted by the parties, the aforesaid factor that the rates are exorbitant becomes wholly irrelevant and rather extraneous. By bringing the said factor into consideration, the relevant factor of the revenue that would be earned by the board have been totally overlooked and ignored. The impugned decision, therefore, is apparently vitiated by the merits in law as well as merits in facts. As regards the argument on viable dates, the law is well settled by a curtain of decisions of the Honorable Supreme Court. In the case of Datta, which I have just now quoted, my lord. Then next paragraph, para 32. The law in this field is well settled. The Honorable Supreme Court in the landmark judgment of Commissioner of Police versus Gordon Das, Bhanji reported in AR 52, Supreme Court 16, has clearly laid down that an attempt was made by referring the Commissioner's affidavit to show that this was really an order of cancellation made by him and that the order was his order and not that of the government. We are clear that public orders publicly made in exercise of statutory authority cannot be construed in the light of the explanation subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of the issue to whom they are addressed and must be construed objectively with reference to the language used in the order itself. The said decision is consistently followed and has reiterated in a number of cases, including the case of Mahinder Singh Gill versus Chief Election Commissioner, wherein the following was laid down. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its viability must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of challenge, get validated by additional grounds later brought out, and orders are not like old wine becoming better as they grow older. In view of the such authoritative pronouncement, the concept of viable date, which was sought to be introduced on behalf of the respondents, is only untenable and therefore doesn't deserve any consideration. Just one more.
Not necessary. Any other point?
Just one, my learned friend may argue from page 71 of the petition, my lord. 29.1. Sorry, 29.5 at page 71.
Yes.
If the bid of the successful bidder if the bid of the successful bidder seriously unbalanced in substantial relation to engineer's estimate of the cost of work to be performed under the contract, the employer may require the bidder to produce detailed price analysis for any or all items of the bill of quantities to demonstrate the internal consistency of those prices with the construction method and schedule proposed. After evaluation of the price analysis, the employer required the amount of performance security set forth in clause 34 be increased at the expense of the successful bidder to a level sufficient to protect the employer against financial loss in the event of default of successful bidder under the contract. So even if you find that the rate quoted is seriously unbalanced, you should give me an opportunity to justify. That's my submission.
My lord, I'll be very precise, my lord. My lord, the first NIT was issued on 13/1/2024. My lord, and then financial bid opening was on 13/2/2024.
13/2/2024.
2024.
Yes.
Then, my lord, on 29/3/2024, the financial bid was rejected of the petitioner as well as the respondent number 6, private respondent. Then thereafter, after rejection, another NIT was floated on 4/3/2024. My lord, after floating of that subsequent NIT, they approached this honorable court. And order of this honorable court dated 12/3/2024. There was an order, my lord, 12/3/2024. Since last date of submission of bid in the subsequent tender was 18/3/2024. There was an order of this honorable court whereby there was no stay in respect to the rejection of the petitioner's bid. However, a liberty was granted to the petitioner to submit his bid in the subsequent subsequent tender, my lord. 12/3/2024. Now, despite the liberty given to the petitioner to submit his bid, he did not participate in the subsequent tender. Neither the private respondent. While allowing the petitioner to submit, my lord, this honorable court has observed that the financial bids of the subsequent tender shall not be allowed to be open without the leave of this honorable court. Therefore, we have opened the financial bid, technical bid, but the results cannot be announced because without the leave of this honorable court. He has not submitted the subsequent, participated in the subsequent tender, nor the private respondent. Private respondent could not. The entire allegation in this writ petition was that the authorities are trying to malafidely favor the private respondent, my lord. So the allegation of malafide goes, my lord. Because private respondent also, his bid was also rejected. He was rejected. He did not even participate in the subsequent tender. So the allegation that in his entire writ petition that we the authorities are trying to favor the private respondent, it goes, my lord. Now coming to, my lord, page 168. Because in our affidavit, we have stated that in para 9, as my learned senior has shown, in para 9, we have stated that petitioner has quoted 14% below the tendered amount, and major items like internal electrification and carrying items has been drastically varied from the approved cost and specification. At page 145, continued page 145, this is our affidavit. Paragraph 9 of our affidavit. So, page 145, para 9. May I read again, my lord? That with regards to the statement made in paragraph 12 of the writ petition, the answering respondent begs to state that the petitioner has quoted 14% below the tendered amount, and major items like internal electrification and carrying items have been drastically varied from the approved cost and specification. Considering the quality and specification, the board constituted for evaluation of recommendation has recommended for retender through so and so there. Then annex copy of scrutiny report is annexed herewith and marked as such. So this is annexure to the very financial scrutiny report, madam, at page 168. My lord will see financial scrutiny, my lord. In the first column, my lord, infrastructure development so and so, approved NIT is 104752 so and so. MSTJ Enterprises, my lord has seen, this is the petitioner, my lord, quoted 9008672 so and so, and private respondent 98 so and so so and so. Below the column, my lord will see 14% below the NIT amount. My lord has seen 14%, and private respondent T Gangkak Enterprises is 5.7% below the NIT amount, L2, L1, L2. L2 was never considered, my lord. Private respondent never considered. The financial scrutiny in the evaluated, it is evaluated that the lowest firm has submitted the low rates beyond the justified rate put up to tender, which are evaluated and computed below. Here, my lord, what are the items where there are drastic variation, abnormal variation, low and high? This has been clearly evaluated by the board. Found out, my lord will see. These are the variations, abnormal variations of the rate quoted by the petitioner. So, after finding, my lord, at the variation, second last column, my lord, first item is 23.5.1% above, then 97.24% below. All these variations have been found out by the tender financial bid evaluating this committee, board. Now, therefore, in the at page 169, the board has correctly said, from the above, what it says, from the above, it reveals that the rates adopted by MSTJ Enterprise, this is the petitioner, is not justified and not acceptable. The other firm, MST Gangkak Enterprises, is not acceptable due to CBC guidelines. Therefore, the committee recommends for retender of the work infrastructure so and so. What is the mala fide in this? What is the arbitrariness? Whether this evaluation is right or wrong, my lord will not go into this. They have given a chart, and this financial scrutiny report has been made a part of our affidavit. We have said that he has quoted 14% below the tendered amount. And there are variations.
Mr. Ratan, you see, is there any explanation?
Yes,
Is there any reason?
this is itself the explanation. The variations have been shown. The percentage of variations above, 23% above in first item. This is above the price, actual price, madam. And the second, my lord will see, approved NIT, these are above the approved NIT, 23.51% is above the approved NIT. Then the second item, 8 carriage charges. This is again 97.24% below the approved NIT.
No, had this explanation put forwarded in the paragraph number 9 would have been in the
Yes.
This
That
is
is
page number 168.
Yes, my
Then we have nothing to do.
Yes, this is exactly the explanation, my lord. We are saying
No, you cannot supplement it.
Yes, we are
by
not
way of
supplementing.
an affidavit.
We are not supplementing. My lord will kindly see. We have stated that the petitioner has quoted 14% below the tendered amount. And major items like internal electrification and carrying items have been drastically varied from the approved cost and specification. Considering the quality and specification, the board constituted for evaluation has recommended for retendering through so and so. This is how we are saying the scrutiny report. And 14%, my lord, I have shown in one page 146, how 14% has been mentioned, where 14% has also been mentioned at page 168. This is 14% is below the tendered amount. My lord, page 146. After the first table, below the first table, my lord will see MSTJ Enterprises below 14%, below the NIT amount, L1. My lord has seen, and the private respondent. So these are the board recommendation. These are the variations. At the time, the board evaluated the financial bill. And because of this tabulation, the findings, the variations finding, the board has recommended for retender. These were already there in the recommendation. We have in short filed it. Details, in fact, details is in the evaluation. Scrutiny, this financial scrutiny evaluation, detail is there. We have in fact shortened our statement saying that the board has recommended and there was variations. We are not trying to improve. We have just shortened. We are not trying to improve our case. We have shortened in our affidavit and there has been abnormal variations, high and low. We are not trying to improve our case, man, because it is already, the detail is already there in the board's recommendation. It is exactly the other way around Moninder Singh's Gill's case, my lord. You cannot improve the public order once publicly made. You cannot improve by way of an affidavit, subsequently bringing grounds in the affidavit. Here, our document gives the details. In our affidavit, we have just given the short version of this scrutiny. We are not improving in our affidavit. If my lord has got
That's all right, but you see in the page number 169.
From the above. Because here my lord will see from the above, this chart, from the above, it reveals that the rates adopted by MSTJ Enterprises is not justified and not acceptable.
How?
Because of these variations.
Where it is explained that because of this variation?
Why not the table?
No, can we presume it that it is there in spite of its absence?
No, my lord. I'll then try to convince my lord. My lord, first description of work in the table. External electrification service connection. Quantity 1. Unit job. Rate approved NIT. Approved is 32,44,362. This is the approved government rate. Amount 32 lakhs so and so so and so. Now quoted by TJ Enterprises. Rate 40 lakhs 7,198. amount quoted is also same. And variation with the approved NIT. This is the variation, 23.51% above the approved rate.
So is there any clarification in that regard in the tender notice itself?
Yes, my lord.
Where?
Clarification that in our tender notice, my lord, at page
number?
my lord, continuation also page 219 also. It's the same.
Yes.
219.
Annexure 4 is the tender NIT, Mr. Mazumdar.
My lord?
Annexure 4, page
Yes,
number 51.
Yes, that is the NIT.
So, is there any such stipulation in the NIT?
About, my lord? About?
This variation?
Variation.
My
My
lord,
lord.
yes, page 70.
29.2,
29.2, my lord is correct. 29.2, my lord. Page 70.
20?
29.2. It says, in evaluating the bids, the employer will determine for the evaluated bid price by adjusting the bid price each bid as follows, making an appropriate adjustment for any other acceptable variation or deviations, and making an appropriate adjustment to reflect discounts, other price modification offered in accordance with clause 23.6. Ultimately, my final rate is below the other private respondent. That is why my one has to be accepted. Thereafter, if authority finds that no, your rate in connection with a particular item is varies, you have to adjust. This is what, in my humble submission, my lord, this is what authority has been given to the employer, that you adjust. You say that so you are charging more in the carriage, but you have to use this money for the purpose of improvement of the quality of the materials you are supplying. Because ultimate rate I have quoted is lower, and the variation is 14% as you are saying. 14%, you are not saying anywhere that 40% is unacceptable in the sense that it is going to compromise the quality and it is excessive. That is not your finding. You are simply saying, because my lord, if the government rate is 5 rupees, if I have to quote 5 rupees, then there is no question of any tender. You can say that government rate is 5, all of you will quote 5 rupees. There will always be a variation. Only thing that has to be determined and assessed is that variation should not be so high or so low. It is only 14%. And that too, my lord, they have checked. And that is why, my lord, it says, my lord, if it is ultimate 29.5, page 71, which I read earlier once, page 71, 29.5. If the bid of the success, I have become a successful bidder. But if the bid of the successful bidder is seriously unbalanced in substantial relation to employer's estimate of the cost of work to be performed under the contract, the employer may require the bidder to produce detailed price analysis for any or all of the items of the bill of quantities. You ask for me. Let's see, you are using more money for carriage and less money for quality supply of certain, say, electrification or something. You change it. Because the ultimate rate that I have quoted is below the other person. That is why I am entitled to. That is my submission, my lord.
My lord, may I clarify?
Yes, yes.
My lord, NIT, before floating an NIT, there is always an estimate prepared, my lord. Estimate of the total work. For preparing that estimate, item rates which the government approved, as per the government approved rates, are also prepared, madam. The item rates. Therefore, the value of the NIT also is known, my lord. Now here, item rates, as per the item rates prepared by the government department, certain approved rates of the government. As per that, they prepare the DPR and this estimate. Now, if there is a variation in the rates, very high, too high or too low, then the department may not accept the tender mark. Now, here in this chart, my lord has seen variations up to 97% below what is the approved rate. Variations up to 81% below the approved rate. My lord will kindly see this. There are so much variations in the rates at page 168.
No, if it is not stipulated in the.
Yes, ma'am, I'm coming to that, my lord.
NIT.
Page 71, my lord. My learned senior has read 29.2, 29.5. Please come to 29.6. This is where we are saying. A bid which contains several items in the bill of quantities which are unrealistically priced abnormally low, high, and which cannot be substantiated satisfactorily by the bidder may be rejected as non-responsive. This is abnormal. The bids rates quoted. There are so many items. Abnormal rates have been quoted. Why should we accept their bid just because they are?
That's all right, but your explanation, your reason in the this order.
Yes, my lord. From the above, it reveals. It says at page 169. From the chart above, the variations shown is in this chart. My lord will kindly understand this. From the above, this is the chart.
Except quoting the variations, you have never mentioned in that order.
No, my lord. Here, from the above, it reveals that the rates quoted by MSP. It is referring from the above means the variations here shown in the chart. Otherwise, the chart will be meaningless. From the chart, this finding is arrived at. From the above, it reveals that. What is revealed? From the above chart, that the rates quoted adopted by MSTJ Enterprises is not justified and not acceptable. The other
That's
firms,
all right. Why it is not acceptable? Because
it is the variation is yes, variation is
abnormally high or abnormally low. Where you have mentioned it?
Well, in the chart itself.
No.
The
You have put it in the SARDA, that's all right, but where you have mentioned in the this in the resolution?
Yes,
Where?
resolution. This speaks
It
from the
simply
chart.
stated that it is
unjustified.
not justified and not acceptable.
Yes.
Why?
Because of the variations shown in this chart. These are abnormal variations. The chart reveals the abnormal variation. The chart itself reveals the abnormal variation. Therefore, when there are abnormal high or low rates quoted for each items, it is not necessary to accept that bid, my lord, as per 29.6, my lord.
There could have been more elaboration in the.
My lord will not even go into this aspect because this honorable court is not required to go into how much variation or not. I'll just so because tender evaluating committee is the one who whether that this at this rate the contractor the bidder can work or not, execute the work or not. My lord will kindly see what the Supreme Court has time and again stated, my lord.
That NG project.
No, my lord. NG project, after NG project, the Tata Motors is there. But on this point, regarding an evolution of price bids, my lord, at para 11, this is of
Afghan and passive, sir.
Yes. This is of 2016 6 SCC, my lord. Para 11, this also recently in Central Coalfields versus so and so
Paragraph number?
11. To the point, my lord.
Hmm.
It was held by this court relying on a host of decisions that the decision-making process of the employer or the owner of the project in accepting or rejecting the bid of a tenderer should not be interfered with. Interference is permissible only if the decision-making process is malified or intended to favor someone. Similarly, the decision should not be interfered unless the decision is so arbitrary or irrational that the court could say that the decision is one which no responsible authority acting reasonably and in accordance with the law could have reached. My lord, here the variation has been shown.
Variation has been shown, that's all right, but there is no explanation.
Explanation is there that it is unjustified because of this variation.
You have not mentioned in the resolution that it is abnormally low or abnormally high.
It is mentioned.
Without, if there is no reason, then it is arbitrary and it is.
My lord, the
irrational.
reason is there, my lord. From the above, it reveals that the rate adopted is not justified and not acceptable.
Why it is
Not justified, my lord.
Why it is not
Not
accepted?
justified because the variation, not justified because of the variations. Here is the variations. Variations have been demonstrated in the chart itself. Because of these variations, it is not justified. If my lord, what I'm trying to, because of the variations already.
You are trying to supplement the resolution with the affidavit.
No, my lord.
Paragraph number 9.
My lord, I'm not trying to supplement the affidavit. Affidavit contains, in fact, an abstract copy of what is in this recommendation, my lord. We are not, it is other way around, Moninder Singh Gill's case, my lord. By way of affidavit, we are trying to improve what is not there in the order. But here in the order itself, it is very clear that we have demonstrated the variations, and for the variations, abnormal variations, we have the petitioner's bid has been found to be unjustified. And my lord, one more, my lord. This is of 2016, and the latest one is last occasion also. My lord, Tata Motors case. My lord, this is that is the recent most one, 2023. My lord, after NJ projects, Bolenat and all that Tata Motors. There also, my lord, has the honorable court. I'll not read, my lord. Relevant portion will be para 48.
Give it.
Yes. From para 48, my lord. 48 and then 49 also. And how courts, while entertaining writ petitions challenging the tender process, how courts should deal. Because honorable, this in a writ court, this writ court cannot substitute the findings of the employer.
No, we are not substituting the view of the court with that of the scrutiny committee. We find that there is no reason assigned.
My lord.
May I quoting the rates? Can we read it as a ground?
My lord, the rates.
From the above, it appears.
My lord, that is exactly what I am trying to convince, my lord. Rates have been compared. After comparing the approved rates, the government approved rates, and the rates quoted by the petitioner, the difference is the variation. The variation has been found out. My lord, may kindly come to page 168 again. I think I'm not being able to clarify, my lord. in the second table, my lord. Approve NIT. 168, my lord, will cancel. This is the government rate, approve NIT. In approve NIT rate and amount for every item. And if my lord sees the TJ Enterprises, that column in the right side, left side rates is the government rate, and the quoted rate of TJ Enterprises has been shown. Then the variation has been arrived. My lord, first item, external electrical service connection. Quantity is only 1. Unit is job. Rate is 32 lakhs 44. This is the approved rate as per the government. And what is MS in the right side, my lord, MSTJ Enterprises rate, what he has quoted, 40 lakhs instead of 32 lakhs, he has quoted 40 lakhs 7,198. So what is the difference between the rate quoted by the TJ Enterprises and the approved rate is 23.51%, the variation. This is the variation. You are 23.1% above the approved rate. That is the variation found out. Because 32 lakhs something is the approved rate. You are quoting 40 lakhs. It is 23.51% above the approved rate. Now the second item again is 8 carriage charges. Carriage charges is this will be 1 crore 12 lakhs 96,898 something. This is the approved government rate. The TJ Enterprises has quoted 31 lakhs 22 31 lakhs 22,700 something. There is 1 crore, and therefore the difference is 97.24% below the approved rate. This is the variation. What is the workable rate worked out by the department is this much, and what they have quoted is this much. There are variations of 97.24%. It is not the variation between the private or price quoted by the private respondent and the petitioner. It is the rate fixed by the department from which they have varied. Therefore, the variations have been worked out, and after working out the variation.
All right, any other point?
My lord, that's all. This is, and because of this working out of the variation, the tender committee has found it is unjustified and not acceptable. Unjustified, that's why not acceptable. And therefore recommended for retender. So what is the wrong in this, my lord? That is only that. My lord will only say they have justified, they have found a variation, percentage variations of the items, and it is too high, abnormally low in some items, abnormally high in some items. Therefore, it is not feasible. Even if work is given, awarded, he will not be able to execute in this way.
Mr. Mazumdar, why you were not interested to participate in the new tender process?
If I participate also, they will reject, because I'll show my lord. My learned friend has said respondent number 6 has not participated. We are saying that they are trying to favor him. Well, page 241, Lordship will find respondent number 6 has indirectly participated again. This is one. Lordship may kindly see
page number?
Page 241. That is the part of the affidavit running page 241. They have not disclosed it, but then same person, His son is there, so indirectly they are there. Page 238, my lordship may kindly see. Page 238, serial number 5, same name. Page 238, my lord. 8 and 241. Serial number 5, same person, Gotem Gangtek. And then page 241, lordship will find through the process of power of attorney, etc. Page 241, my lord, second line, his name is there.
Different.
No, his bid was also rejected, then how they can, how the question of favoring him arises?
Well, what I am saying is, well, his bid was rejected. So, in order to accommodate him, my lordship will kindly see this, so far as the financial, the committee is concerned, the committee to evaluate, their job is only to see whether my financial bid is responsive or not. The committee goes a step further to say retender. Why? You are not the authority. It is for the employer to decide.
Is there any mention about
Yes,
tender?
yes, ma'am.
Where?
Lordship, may kindly see. What authority the committee has, my lord? Page 160.
Committee recommend.
Yes.
No, is there any bar in recommending?
There is no bar, man. The committee, he is authorized only to say whether the financial bid is responsive or not. There they should stop. They want a retender, my lord. Our humble submission is
No, Mr. Mazumdar, you see, inquiry authority and disciplinary authority.
yes, more or less same.
Inquiry, no.
More or less same.
No,
Inquiry authority will
inquiry officer can recommend anything, that he may be dismissed service, dismissed from service, or though it is not contemplated, he can make such recommendation. So what wrong with this committee that
I am saying, my lord, under the tender conditions, he is to say whether it is to be rejected or not. My financial bid is to be rejected or not, because final call will be taken by the employer. But if he recommends, no, please retender, I am only trying to show that there is a malafide intention. And secondly, response number 6 is indirectly there. And my lord, as I have said, I am just making one submission, maybe it will be a repetition.
So what do you want to project by this page number 238?
Page 238. Well,
yes.
By showing P238.
Representative of DT construction line.
Yes. Page 237, my lord. Serial number 5. Response number 6 is there. Fresh, and then fresh.
Yes.
Then page 85, Dr. may kindly see for a moment.
85.
85.
Is there any pleading that they have retendered it only to favor the?
Yes.
Is there any pleading in the petition?
In the rejoinder, when they have filed this affidavit, we have filed a rejoinder taking a specific plea of that.
Rejoinder.
Yes, ma'am.
Rejoinder.
Something like that.
At page number, rejoinder is at page number?
Region number will start from page number, possibly 240. 42. No. Para 5, we have taken this plea.
Para 5 of?
Para 5 of our rejoinder, madam.
At page number?
Page 3. Internal page 3, madam.
No, you say
it will be running, madam. Page maybe 240. No, what is it? 41 last. Their affidavit is page 241. It will be 246 or 7 million. 42.
246. No, here.
45.
Last page is 241.
Yes, so it will be 245, para 5. I put it in research.
My lord will only compare the name at page 85 and
The father, my lord.
page 421.
85.
85 and 421.
85 is father.
These are all allegations in the air, my lord. 485, 85 is another, and
No, no.
421 is
No, no,
another.
no. Same. Because father.
I don't know.
Other is at page number
85.
85 and
85.
Acha.
85 is father. Now this is another firm. 241 is another. TD Construction. Earlier is T Gangkak Enterprise. This is TD Construction House. Authority is, proprietor is Togobasa. The authority is given to one Sri Gotum Gangkak. Earlier proprietor is the private respondent T Gangkak Enterprises. The proprietor is Tugo Gangkak.
Rejoinder. Copy dia. Itu opposition. Na rejoinder tu nahi copy দিব লাগিব। Rejoinder itu file নাই। And my lord, day before yesterday it was filed.
Pardon?
Rejoinder was filed day before yesterday. It may not
Never
be-
filed.
Saturday. Saturday it was filed, so it may not have been tagged.
Saturday he has filed.
He has filed rejoinder from where I'm showing paragraph. We can give an extra copy.
My lord, it may take into account that this honorable court did not stall the subsequent tender, my lord. And it allowed the petitioner to also participate. Only the
No,
financial.
his apprehension is that again his tender may be rejected.
No, my lord. Because this honorable court also, while issuing notice, did not find any discrepancy in the
No, that
This
was at the
plotting of
motion
the-
stage.
Yes, my lord.
While stay was granted.
My lord
But
will only
now we are
see
here-
page 168 and 168, 169, whether it is sufficient ground, whether there is any illegality in that. Page 168 and 169. That
No,
is
I am not on that. I am on the point that there is no reason. If
168 and
there is no
169.
reason, then it is arbitrary.
The reason is there in 168 and 169, what I believe, that the variations
No,
have been
that
found
is-
out.
My lord,
That is there.
my one submission I make. My learned friend, your lordship is asking, my learned friend is responding. My learned friend is saying that the reason is there. There are two words, it's not acceptable and
Unjustified.
unjustified. The rest of the reasons which your lordship is asking for from your court, my lord, my learned friend is supplying, like my learned friend's planned. So that is coming within the mischief of Mohinder Singh Gill. That you cannot supply fresh ground. You have said, I'm not accepting you, but on what ground? Is it because low rate or is it because high rate? Because percentage wise, I have shown my lord, in one case, there's a 97% below, and that is in the case of carriage. And while carrying materials, if I can carry materials at a low rate, it is good for you. 97% low in which item? In an item which is a carriage. For carrying materials, if I charge less, you are beneficial. You will be benefited. Has your lordship
It will
seen
not
that?
affect the quality of the work.
Yes. And other items, my lord, there may be some variation. If the variation is abnormally high or abnormally low, then they can take a call. Nowhere they have said it is abnormally low. Now they are supplying by way of affidavit and argument. And that's my submission. Lord will consider. And the regarding response number 6, my lord, even in the writ petition paragraph 17, we have taken plea. Writ petition also. para 17 at page 21, my lord.
Mm.
Somewhere in the middle, my lord, below that Act, my lord, 2015,
Mm.
it appears since the work could not be awarded to private respondent number 6,
Mm.
the respondent authorities had cancelled the tender process itself. So we have taken a specific leave. Not that we have not taken. Lordship will consider, my lord. We have taken Lordship's time.
Okay.
And my lord, in my two judgments, the Honorable Apex Court has also dealt with the writ petition filed on by an unsuccessful bidder, my lord. Whether to entertain that. I'll not
No,
travel.
that is that is not the ratio of the said cases. Nowhere in the NG project also it is stated. But when there is arbitrary and when
Yes,
there
my
is
lord,
a
exactly, my lord. Where there is
illegality,
a arbitrariness,
interfere.
my lord will only consider page 168, 169, whether the variation is a reason for rejection, whether that is arbitrary or not. If there is variation, abnormally high and low variation, whether it is not a ground for rejection. That is only to be decided. And the variation is variation from the government approved rates.
Okay. So there is urgency.
Yes, my lord.
Your work has been stalled.
Yes, my lord, because it's a tender, time-bound tender, my lord, and almost going to be 1 year, the pendency, my lord. This was filed in the month of February. In fact, earlier they had taken enough time because they also knew this would not succeed. So they wanted to withdraw it. They wanted to earlier Mr. Panging was handling. He wanted to take instructions from his client because he also knew that this would not succeed. So for that, there was a delay.
Delay in disposal of the case.
Yes, my lord.
Okay. Heard Mr. D. Mazumdar, learned senior counsel assisted by Mr. D. Devi.
Miles.
Learned
SK
counsel.
Devi.
SK Devi, learned counsel for the petitioner, and Mr. N. Ratan, learned additional advocate general for the respondent number
1 to 5.
1 to 5. Mr. Tagum for respondent number
6, madam.
6. Any submission on your behalf?
I'm endorsing the submission of the learned.
Endorsing.
Because I'm no more, madam.
You are no more.
But I'm unnecessary. I've been pleaded here.
That's anyway, in respect of the other matter, Mr. Pisa,
Item 11.
ready. So within 15 days, you will be able.
My learned friend is saying he has also talked to his client. They are saying they are going to make the fresh tender for procuring materials from March 25. So Lordship, he said that a little more time. He can complete, but then
we are giving some exception, my lord. It cannot be extended for 2015, my lord, or 2025, my lord. Only 15 days we can give. Otherwise, this matter may be taken up on merit, my lord.
Also, this entire thing, the tender which has been quoted by the department in the press, which is being challenged before this honorable school, that is for 2024 to 2025. That financial year will be end in the month of March 2026. Now the work which I was being executed also, which is supposed to be completed, but due to some that 3 reasons we could not complete it. It is built and the work will be completed on the 31st March of 2025.
Okay.
That's all.
So 1 month.
15 days, because we are.
Continue this financial year because other tenders.
my lord, your lordship's hand is very long. They may say, but ultimately justice will be done by your lordship. We will leave it to your lordship.
That's all right. You have prayed for 15 days. I am giving you 1 month.
My lord.
Would it not be sufficient?
This till they issue the press and avoid the.
Well, who will pay them? Who will pay them? Well, that is the question.
No. You complete it within 1 month.
That is, my
No
lord,
further concession.
my lord is having too much of leniency to them. Otherwise, this petition is not maintainable, ma'am. I am appearing for respondent number 4. ma'am.
Anyway, let them complete it within 1 month.
And the press tender that is already floated, that may not.
It will take another several months, no?
No. It will only take hardly 15-20 days.
And if
It has been submitted by the bidders, madam.
if the subsequent bidders also fail to complete it within time, then
No, bids have been submitted, my lord. Due to the confusion of the interim order passed by this honorable court, they have not processed for it. But otherwise, there are traders who have participated, they have submitted their.
Okay.
Let us give it one more time. In the meantime, we'll complete the work and whatever bill will claim it and they can proceed with the new tender.
No, madam. See, madam, they were given a tender for the year 2000, financial year 2023-24, madam. This is the financial year 2024-25.
Yes.
Now they are claiming as
They
an
do not have
extension
the
for
right.
financial year 2024-25.
No, no,
How
no,
can it be
no,
possible?
no, no.
That is why, madam.
No.
That is the issue, madam.
No.
Yes, ma'am.
We are not-
Only 1 month from today.
My lord.
Madam.
Yes, madam.
Lordship, item 26, I was waiting. It's an urgent matter in the sense that it was for consideration of interim order. Can it be taken up tomorrow, Lordship?
1 month from the date of submission of the court's order, because otherwise during the process, court's lordship's order. will
Madam,
come.
Yes,
Madam, we are representing, madam, he is for the PD, I am for the director, madam, they can supply, madam, from today, madam. PD is here, madam, PD is here, madam.
PD is here, PD's counsel is here, I don't disbelieve PD's counsel, but PD has done the whole mischief. He has not recommended, they have filed a clear affidavit saying that PD has not said yes, no. He has said nothing.
okay.
Otherwise, on merit, if they have to go.
Yes.
Lordship, item 26. Item 26. Lordship, it may be taken up tomorrow, Lordship. It's a very small matter. This is just for consideration of interim order.
Okay.
Tomorrow, Lordship. Oblige.
Lordship,
Take it that for ma'am.
item number 27, matter may be fixed for tomorrow, your lordship.
30?
No, 27, your lordship.
27.
Yes. It's a promotion
Hearing
matter.
matter.
Yes.
Okay.
Much obliged, your.
So the NIT of 2024-25 may not be, madam, interfered, madam.
May not be?
May not be touched upon.
Interim order earlier passed may be vacated.
Vacated,
It is pressed.
Definitely, that order will merge with the final order.
Yes, ma'am.
Your lordship, we had taken steps, item number 24 and 25.
25.
24 and 25. On the previous order, we were directed to take steps and implead respondent number 4.
Whether a service report received?
Your lordship, we have filed this IA in order to implead commissioner of.
Okay, well, let it be listed tomorrow.
Okay, deeply obliged.